Hey. How are you? All right, ladies and gentlemen, I have not quite 9 o'clock. We'll call the dockets in a moment. I'm going to ask everyone to keep your electronic devices muted when you're not actually speaking. I'll call the dockets, as I said, ask for announcements from the attorneys. Anyone who has an attorney, who your attorney isn't present or your attorney doesn't answer for you, make sure that I know that you're here. And I'll let the attorneys know I am suffering computer issues. So we have not sent out a formal email, but we plan to resume jury trials, the first regular jury of June, and we plan to resume in-person court in May. So that's where we stand right now. All right, we had people coming in late. All right, let's start with LaSalle civil matter of the marriage of Brozak. Ms. Pearsall.
Sorry, Judge, I couldn't find my mute button. We are ready. It's a prove up. It should take a couple.
Okay, you're breaking up, but I'll mark you number 1.
Thank you.
Okay. Wilson County civil cases in the interest of Madison Brooke Balmas, a child, Ms. Barrera.
Yes, Your Honor. The other side's pro se. Her name should Julie Fox. She should be on because I spoke to her Saturday.
I'm present, Your Honor.
Okay.
Okay.
If we can confer after the docket.
All right, I will mark you conferring. Fox, I'm going to ask Ms. Riley to place you in the breakout room. That's a separate electronic room you can go to and discuss this matter with Ms. Barrera. All right, 13-12-721, in the interest of BDW, a child.
Good morning, Your Honor. Anthony Bancroft for Movement Sheldon Walpole.
Good morning, Judge Rashid Mazaheri for respondent Laura Walpole.
Okay, and is the Attorney General's office involved in this?
No, Your Honor, they're not. We have a motion to compel discovery and a request for appointment of reunification therapist. Ms. Mazaheri and I have conferred this morning. We think 15 minutes, maybe 20 at most, to resolve this.
Okay, I'll mark you 20 minutes in conferring.
Thank you,
In
Judge.
the interest of Edward Stantine Jr., a child.
Yes, good morning, Your Honor. Piana Aldridge, I represent the petitioner, Ms. Lakendra Hastings. We have a submission of orders as well as 2 motions. I don't believe it's going to take more than 20 minutes. I don't know if Ms. Thomas has representation now. She emailed me on Friday saying that she should have representation today.
All right, Ms. Thomas.
I'll have representation this afternoon, Your Honor.
Okay,
It's in the works.
okay, has there been a sworn response to the motion to transfer?
No, Your Honor. There has been no controverting affidavit filed in this case.
Okay, and you're asking to have this sent to Bexar County?
To Hays County, Your Honor. That's where the child and my client is.
Okay. And all right. All right, Ms. Thomas, if there is not a controverting affidavit on file, I believe I have a duty to go ahead and sign the motion, the order on the motion to transfer. So all that means is this case will be held in the county where the child resides. And I'll ask Ms. Aldrich to post a order to me to that effect in chat.
I will, Your Honor.
I will sign that.
I also have 2 short motions, if I may.
Okay, what are those?
Well, not motions. There's a submission of orders, Your Honor. I did send that to Ms. Thomas, and she indicated she was not going to sign anything, but you had ruled on temporary orders on March 9th, and the only thing that I wanted to clarify with you was whether or not the child support would transfer to my client, who you had given.
Yes.
Yes, okay. So I will send that, and also there's a motion for removal of some of evidentiary evidence that she had filed in the case. So I'm asking that to be struck and removed from the files.
And is that set for hearing today?
It was just filed last week, so I threw it in there. I didn't know if I could take it up today, but.
Okay, well, we'll leave that for Hayes County. All right,
Yes,
Ms. Thomas, did you have a particular objection to the order other than the child support issue that Ms. Aldrich came up with? Or were you just on the general principles that you hope to have an attorney soon and you did not want to sign off?
I do not want to sign off because I don't have an attorney present at this moment.
Okay, that's fine. Then I will sign those orders when they're submitted, and you'll be able to get a copy from the district clerk's office sometime after they're filed. Ovation Services LLC versus Carlos Olvera.
Your Honor, I'm here for Ovation Services. We're asking the court that the case be dropped today and reset or continue for not less than 60 days.
Okay, I'll put reset on request. Is that all you have?
No, I've got one other one.
Okay. In the interest of Grayson Richter, a child.
Your Honor, this is actually just a motion to enter a quadro because it was after the 30 days. He never filed an answer after being served, so we're just trying to enter the quadro.
Okay, if you will post that to me in chat, I will sign it. Or do you need to put evidence on other than?
No, it's just following the decree, Your Honor.
Okay, all right. The matter of the marriage of Roy and Lacey Lynn.
Petitioners present, Judge.
Your Bird Bonner for the movement. It's a motion for additional temporary orders. It's rather limited in scope. What do you think for a time announcement, Lisa?
Maybe 30 minutes.
I think 30, 45, I'd say 45 minutes, Judge.
Okay,
Make sure.
all right.
I mean, we already have temporary orders, Your Honor,
Okay.
that already provide for some of these things. So I think
All
Mr.
right.
Pine is really trying to modify them.
Okay, I'm going to ask you to confer. Two, have I heard anything previously?
It looks like,
I think you heard the temporary orders. They were from December of 19, I believe. They're over a year old.
yeah, Your Honor, you entered the temporary orders back in December of 2019.
Okay, and I'm assuming at that time, but I let everyone know that I know Roy Lynn. He's a good guy. We're not close friends. I knew him since he was young. We're not Facebook friends or anything. I'm not even on Facebook anymore, but I have known Mr. Lynn since he was in elementary school, probably.
Mr. Bonner and I were not even attorneys of record at that time. So I guess.
Okay, so I'll let you all.
Judge.
He has done some, he's a contractor. He has done some work for me. And in fact, my wife and I were considering having him do some more when our income tax refund comes in, if it ever does. It's been about 6 weeks. So I'll let you all discuss that too.
Well, Judge, what are our options for referral to a different
All right, then I'll
judge?
excuse myself and ask y'all to get with Miss Riley and get that in front of Judge Ellison.
Very
Okay.
good, Judge.
It may be that it
We'll
was,
confer when we do
it
that.
may not have been contested last time. I don't.
I don't think it was, Judge. I think it was an agreement, but since
Okay,
it is.
yeah, I don't recall ever hearing something contested with him. All right,
Yeah, it was.
Okay, Mr.
Ms.
Bonner and I
Riley
will
can
confer.
call.
okay, Miss Riley, can you?
Thank you.
All right, Vanessa and Martinez and Maria Mendoza versus Brandon and Sarah Freeman.
That case was dropped, Judge. We received a call from Ethan Shaw's office on the 26th.
Ovation Services versus Stephen Rose.
Your Honor, I'm here for Ovation Services. I believe the other parties are here. This is for a trial on the merits. It's about 20 minutes.
All right, is Mr. Rose here?
Yes, sir, I am here.
Okay, there you are. All right, Mr. Rose, I'm going to ask you to confer with the attorneys in a breakout room. That's you may have heard me tell the other pro se or self-represented individual, a separate electronic room that you'll have a chance to go and confer with them about. I think this is the case where I took a default and then that was the day after the time change.
Yes, sir.
Okay, I'll mark you 60 minutes and conferring.
Your Honor?
Yes, sir.
I'm sorry. I said it would take about 20 minutes, not 60.
Oh, okay, all right. I'll still 20 minutes in conferring.
And I think Jeff Garcia is the intervener. I think I saw his name pop up.
Yes, good morning, Your Honor. We're ready on that also.
Okay, all right, Mark, you conferring. Okay. Ex parte Kevin Frank Longoria.
I'm present for that, Your Honor. I'll confer with the state. I believe an answer was filed.
Is there someone here from the state?
Your Honor, I also received that from DPS, and I'll visit with Ms. Tapia.
Okay, I see it has her down as the attorney for both sides.
No.
That means you're going to break even. You have one loss. Okay. Another expunction, Joe Garcia.
I represent Mr. Garcia, Your Honor. I have not received any answer from any of the parties that I've served.
And state has no objection to the expansion, Your Honor.
Okay, I'll mark you number 2. Wilson Criminal Add-ons, Jason Nitz. Oh, I'm Wilson Criminal. Let's go to Wilson Criminal first. Anybody else told to be here today on a civil case only? All right, I'll let the attorneys who need to confer. State versus David Greenwood.
Good morning, Your Honor. Counsel's present. Mr. Greenwood is present. We have a motion to modify conditions of bond this morning, asking for the removal of a GPS ankle monitor. I'm going to have 2 witnesses. I think it'll take maybe 10 minutes for my part at most.
All right, what says the state?
The state would agree with that, Your Honor. It should be a very quick hearing. State has no witnesses.
I'll mark you 10 minutes.
Thank you.
Your Honor, I'm sorry to interrupt you, but I thought, were you going to send me and Mr. Rose into a breakout room? Because nothing popped up to do that.
All right, Ms. Riley is the host. She will do so.
Thank you. I'm sorry, Your Honor.
That's fine. State versus Dennis Lee Smith.
Your Honor, that's an MTR. Just Mark is conferring with the state.
Okay, is Mr. Smith present?
He is
he's in custody.
Nicholas Moreno.
That's going to be a bond hearing and he's in custody.
Jennifer Settles.
Jackson Lynn.
Hello?
My office. I'm turning the computer around so you can see now. She's here now. I received discovery from the state last week. It's voluminous, and there's a recording on a cassette tape, and I haven't been able to listen to it yet. So we're going to check in with the court, ask for a little bit more time to review discovery, go over it with my client, and see what our options are.
Okay, and you'll see that there have been dates posted in chat, just to let everyone know. We're going back onto regular settings. We will be, it says here, what, 6/1. That's a short week, I think. It's just a 4-day week for the first jury trial. But we'll be looking on June 1st, having jurors in and picking juries. So whenever you get your dates, if you need an additional pretrial, there's 4/21, but then it needs to go to docket call and jury selection on June 1st, unless we make some other arrangement. There's a number of attorneys that I'm not familiar with. Whenever you have the dates, as long as there's no disagreement between the state and the defense on what dates it's going to, if the defense counsel will just post in chat to everyone, cause number, name, date. Nothing else, nothing extraneous. Cause, number, name, date. After you do that, you're excused. All right, Gregory Hobson is in custody. Spoke to Mr. Adams earlier this morning. He is on his way back to his office. And his expectation is that there will be a plea, but not until Mr. Hobson has some more time in. So if that changes, he said in case he changes his mind, he went ahead and sent Ms. Sawyer's the paperwork. State versus Cole Pavlik.
Your Honor, Louis Rosenberg, Mr. Pavlik's with me. We've talked to Ms. Whitley and we'd like to reset for May 3rd.
That's correct, Your Honor. We spoke last week prior to, I believe us knowing that you were getting ready to establish the 3 dates again, Your Honor. I think we're pretty close to it, this case being resolved. I don't believe it needs to be on the trial track, Your Honor. I just need to get some more information from Mr. Rosenberg, and then we'll be able to resolve it.
Okay, just go ahead and post your dates. Nicholas Puente, Mr. Ernst.
And Your Honor, he should be present. I believe it's the fire tablet he just signed on. Mr. Puente, can you hear us? There he is waving his hand.
Now can you hear me, sir?
Yeah,
Yes.
there you go.
Yes, sir.
All right, I'll change your name. Thank you. Antonio Morales, Mr. Nitz.
Your Honor, that's my client. I believe he failed to appear at one setting and they picked him up, requesting a he be placed back on the, he's in custody and will be requesting that he be placed back on the PR bond.
Okay. Mr. Puente, I'm going to mute your phone again. Please leave it muted if we're not speaking to you directly. Sean Spalding.
I'm here on that. He should be there at probation. It is a PSI and we're ready.
State's ready on that, Judge.
He is here, Your Honor.
All right. I have not reviewed that PSI. Let's see what, give me a moment on that. All right. State versus William Bauer. All right, this is a sort of an orphan first setting. Did he call up and ask to be put on this by himself, or?
Your Honor, he was previously in Gonzales ISF and got released earlier this month.
Okay.
He was also advised to report today for probation in court, and he is not here.
All right, I will mark him no show. All right, add-ons now. Stephen Dotson, Mr. Nitz.
Yes, Your Honor, this is a plea.
Okay.
We're ready for that.
And have I been sent the paperwork?
Yes, sir. I have emailed all 7 counts to you, and the jail has the thumbprint pages, and he is in custody.
Okay. I will go back and look at that shortly in an effort, because my computer is working not well, but acceptably at the moment, in an effort to keep it at that level. I am not going to have more than 2 apps open at once.
If you would like me to bring his file to you, if you want hard copy.
I can get him, I think. I don't want more than 2 apps open at once.
Or
So,
if you need me to post something, share it, let me know.
yes, if you could post all that in chat, that would be good. That way I don't have to go back in and if somebody would also post the PSI just to me in chat, that way I don't have to go back into my mail and open it up.
Okay, I will send everything into chat to you.
Okay, is that everything, everyone? Anyone else told to be here today? Your case was not called? All right. Start out the matter of the marriage of Brozak, Ms. Pearsall.
Yes, Your Honor. I'm ready. We need to swear in Ms. Brozak.
Where is she?
I'm right here.
Okay, all right. Do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, ma'am.
Thank you, Honor. Judge, I e-filed the decree to be signed on Sunday per your court instruction. Do you need me to do anything else? Do you need me to add it to the chat or?
If you could send it to chat, I would appreciate it, because like I said, I'm trying to keep just 2 apps open.
Right, that's why I asked. Okay, so while I'm doing that, Crystal, state your name.
I'm Crystal Brozak.
Okay. And are you currently married?
Yes.
And who you married to?
Michael Brozak.
And have you lived in the state of Texas and Bexar County for and LaSalle County for 6 months before we filed this petition?
Yes, ma'am.
And are you seeking a divorce from him?
Yes, ma'am.
And have you two reached an agreement as to the division of all your property and all your debts?
Yes, ma'am.
And are you asking that the court approve that agreement today?
Yes, ma'am.
Now, while you guys were married, was there any issues with abuse or alcoholism that your husband suffered from?
Yes, my husband was or is an alcoholic, so we did suffer from verbal, mental, and emotional abuse while he was in the household.
Has he ever been arrested for DWIs?
Yes, twice.
And did he have to go to treatment because of that?
Yes.
And did that make any difference?
No, ma'am.
Okay, why do you say that?
He used the treatment as a time to convince people that things were changing, but they did not. As soon as he would leave AA or any family counseling, he would drink. And while drinking, he was abusive.
And when you say he was abusive, can you explain to the court what you mean by that?
So towards my children, he wouldn't let them come out of their bedroom because he felt that they made too much noise. So he would become verbally abusive towards them. And then he would become physically abusive towards me when I would try to protect them.
And your children are 5 and 4 right now, correct?
5 and 3.
I'm sorry, 5 and 3. And so they were even younger at that point.
Yes, ma'am.
So are you asking today that his parental rights be terminated?
Yes, ma'am.
And do you believe that that's in your children's best interest?
Yes, ma'am.
And he, in fact, believes that's in the children's best interest. Isn't that true?
That is correct.
And so he has signed a voluntary relinquishment of parental rights that he has asked that be presented to the court, correct?
Correct.
Okay. Your Honor, that's all I have.
All right, ma'am. All right, and has there been a waiver of citation filed? Is this a default?
Judge, he signed an affidavit of voluntary relinquishment that I provided to you in chat. Along with the divorce decree. His relinquishment was filed, I believe.
I don't see a signature in the divorce decree.
No, he didn't sign the divorce decree. He signed the affidavit of relinquishment, which waived service in it. And I actually think he signed a waiver of service as well, if I remember correctly. Yes, he signed a waiver of service as well, which was filed on January 15th of 2021. I can add that to the chat if you'd like to see it.
It's fine. No, I don't. I guess that was not a clear answer. Right, and Ms. Brozak, why wouldn't it be better to simply order your husband not to have any right of possession or visitation with children, but keep him paying child support and providing healthcare insurance?
Because he is extremely angry, and knowing the man that I was married to, he would want, if he had to pay child support, he would want to take my children. And one of my biggest fears is that he would drink while having my children and something happen when I'm not there to protect them.
Okay. And how old are the children again?
5 and 3.
Okay. And you're asking to have your name changed to De La Rosa?
Yes, sir.
And is that a previous name?
Yes, sir.
Anything else?
No, Your Honor. Arrest.
Okay, all right. I'll find I have jurisdiction to hear this matter. The case has been on file for more than 60 days. There is a waiver of citation. It's been on file for more than 10 days. There is also an affidavit of voluntary relinquishment, which has been executed by the respondent father. And find that it's been shown by clear and convincing evidence that it's in the best interest of the children to terminate parental rights of their father. And I will do so. I will also find that the petitioner had been a resident of LaSalle County for 90 days in Texas for 6 months prior to the time this lawsuit was filed. And are you asking for cruel treatment or just for incompatibility?
Incompatibility, Your Honor.
All right. All right. And I'll find that the marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. I'll find that there were no other children born or adopted during the marriage. And did you ask about a child being expected?
I did not, Judge.
Ms. Brozak, have there been any other children born to you since the date of your marriage?
No, sir.
And are you expecting a child?
No, sir.
Did you adopt any child?
No.
All right, and no other children were born, adopted, or expected? I find that the orders concerning the children and the children's best interest, and I will approve them. I'll find that the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. And I will restore the petitioner's previous last name of De La Rosa, given the ages of the children and the fact that their father's parental rights are being terminated. I will also change their last names to De La Rosa. Any relief that does not appear in this judgment is denied, so this is a final appealable order. All right, and Mr. Carvajal, I am going to post a copy of the signed decree to you. And Ms. Pearsall, I will send you one, although I have, it obviously is file stamped.
Thank you.
And your excuse, have a good day.
You too, Judge.
Okay.
Thank you, Judge.
All right, ex parte Joe Garcia Let me pull that file. Give me just a moment to look at the file. All right. Looks like there's been an answer filed in the Joe Garcia expunction. Do you have your proposed order?
Your Honor, I apologize. I had just filed that. I realized that I had failed to do that at the time I had filed the expunction. And it is being approved by the district clerk right now.
All right. Well, as I said, I've had ongoing worsening computer issues. There's supposed to be a new laptop ordered, but it's not arrived. If you could post that to me in chat, I'd appreciate it because I'm trying not to have more than 2 apps open at once. I have Acrobat and Zoom.
No problem, Your Honor.
And on Kevin Frank Longoria, have you ever heard anything from DPS?
Miss Tapia's in a breakout room, Judge, with Lorena.
Okay. And the DPS, yeah, they filed an answer. Yes, ma'am. Oh. Thank you.
And Your Honor, I believe I've sent you the proposed order through the chat. For Joe Garcia.
Yes. Okay, I just posted a copy, that signed order to Ms. Tahada and to you. That's all you have?
That's it, Your Honor. May I be excused?
Yes, sir.
Thank you, Your Honor.
Your Honor,
Yes, ma'am.
on the Cnty case, I just posted both orders for your signatures. Do we get excused or do you want us to hold tight for the sign orders?
One, they haven't come across. Two, let's hold tight because about 10% of the PDFs that get posted to Zoom become corrupted.
Oh, no.
Grace Barrera sent me something earlier this morning, a Quadro that I can't open.
Do you want me to e-file it as well?
No, just,
Hold tight.
yes, I'm trying to see here. You sent that just now? Oh, here it is. Okay.
Okay.
Jason Nitz, if you can go to breakout room 3, please.
Okay, I've just sent Ms. Tahada, Ms. Aldrich, and Ms. Thomas copies of the order to transfer and the temporary orders that have been signed. Ms. Aldrich, Ms. Thomas, you are free to go if that's all you have.
Thank you, Your Honor.
Okay, who are we doing a plea packet on? Spalding?
No, Judge, that's the sentencing on Dotson.
Okay.
Add on.
Okay,
And Jason Nitz and Lorraine are in a breakout room, Judge.
okay.
And Your Honor, I have an announcement on my expunction case.
Yes.
We're going to drop that set. We're going to drop that right now, Your Honor.
Okay, reset on request.
Yes, Your Honor.
All right, sounds good. I looked at the file. You have to let some time run. Okay.
Yes.
Right. And do you have anything else?
No, I do not, Your Honor. May I be excused?
Yes.
Thank you.
Have a good day.
You too.
Your Honor, if I may, we have an announcement also on the Ovation Services versus Stephen Rose.
All right, is everyone here on that case?
I'm here, Your Honor.
See you, Mr. Rose. Yes, go ahead.
Your Honor, we've conferred and we've agreed that the court signed the judgment. However, we're stipulating that Ovation Services will not institute any foreclosure for 60 days.
Okay, and Mr. Rose, is that your agreement?
Yes, sir, I do agree.
All right, I'm glad y'all got something worked out. If you will post that to me, Mr. Barrientos, Barrietto, I'm sorry.
I think
somebody's done that.
I think the judgment's already been proposed to you, Your Honor. I think it's already there.
Okay, then let me.
Judge, it's an e-file, so he can still post it if he needs to. I haven't sent it to your queue.
Yes, sir. All right, I'm having trouble here. Hold on. Yes, sir. If you would post that in chat, I would appreciate it.
I'm not sure what you mean by that.
Okay, if you have a PDF copy, if you will just go to chat, as long as you're not on a tablet, if you're on a computer, you should be able to go to my name in chat, and there'll be a little icon that's like a piece of paper that says file, and you can send that to me, and I can sign off on it.
Thank you, Your Honor. We'll do that. Is that it? May I be excused?
Let's wait for it to come through.
Okay.
Because like I said, I've already had one this morning that didn't come through properly.
Okay, let me go and attempt to do that real quick then.
Thank you.
Thank you.
Your Honor, may I advise the court about William Bauer?
Yes.
I contacted Gonzalez IFSF. He is actually still in custody there, and his projected release date will not be till May 20th.
Okay. You want to just pick a date in the middle of June, Ms. Riley?
Yes, Judge, let me get that for you.
Thank
You said May the 20th would be the date of release?
His
Early
projected
June.
release date, yes.
June 22nd?
That'll be fine.
All right, and this bond motion, Ms. Sawyers, what case is that in? Moreno? I'll go back.
Oh, that's Antonio Mar, oh, no, that's different.
Judge, there's one in Nicholas Moreno, and there's one in David Greenwood.
Okay, right, I wasn't sure which one. That's okay, let's get rid of Dodson first if we can. Mr. Dodson in custody?
Yes, Your Honor, he's in custody.
Oh, I'm talking and they're not hearing me because I'm not. Okay. All right. Both of them are sent to you, Your Honor, both Nicholas Moreno and David Greenwood.
Okay,
You'll find Moreno's right underneath the last Dotson document.
all right. All right,
It
if we
just says motion to reduce
over
bond.
here,
Jail. Oh, there he is. He's up.
I got Dodson here.
all right, give me a moment to look this over.
Sturdy before the Daniel. How sturdy?
And do we have Mr. Dodson's thumbprints?
The jail has the pages to get them on, but I don't know that they've attended them yet.
Okay. Y'all want to go ahead and start on that? And actually, if you can get just one really good one, we can use that on all of them since we're doing this electronically, I think.
Okay. Davis, did you hear that?
Go ahead and start getting his fingerprint.
One thumbprint and get it back to me electronically so I can get it over to the judge, or else drop it in chat for the judge.
Okay, let me get the sticker for it real fast.
Did you, I sent over the thumbprint sheet. Booking has the thumbprint sheet.
Okay, I'll have to go grab it.
But you get good prints off those stickers, so that's great.
Either way. And on count 7 judgment, Your Honor, it has a court cost on that front page. Can you remove that, or do you want me to send you a fresh one? The $290 court cost should not be on count 7.
All right, give me just a moment. I haven't opened the court cost yet. Yes, if I can get to it, I can do it.
Okay.
I'm just going through looking at them. All right, calling State versus Stephen Dotson Jr. Are both sides ready?
State's ready, Judge.
Defense is ready.
I'm asking the jail to unmute Mr. Dotson. I can't tell if he's frozen up or.
I
No.
think Davis stepped out to go get
Okay.
that thumbprint page.
Hold on, Mr. Dotson. Let's wait for the bailiff to come back. All right, are you Stephen Dotson Jr.?
Yes, sir.
Is that your true and correct name?
Yes, sir.
All right, Mr. Dotson, can you speak, read, and write the English language?
Yes, sir.
Are you a United States citizen?
Yes, sir.
All right, despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and/or a denial of naturalization benefits. Do you still wish to enter a plea in this case?
Yeah, guilty.
Okay. Do you have any history of mental health problems or mental illness?
Yes, sir.
What sort of problems?
Paranoid schizophrenic.
All right. Has that issue kept you from being able to speak about this case to your attorney, Mr. Nitz?
No.
Have you been able to understand what Mr. Nitz has told you about what your rights are and what your options are?
Yes.
Have you been able to make him understand what it is you wish to do?
Yes.
All right, counsel, do you believe your client's competent to stand trial?
Your Honor, there was a competency evaluation and they have found him competent.
Yes, and that's attached to a reference in the discovery. All right, sir, you stand charged by indictment with 7 different felony offenses, all alleged by the grand jury to have been committed in Wilson County, Texas, on or about, which means on or before, March 20th, 2019. Count number 1 is the offense of burglary of a habitation. Specifically, it's alleged that with the intent to commit a theft, you entered a habitation without the effective consent of Christopher Watson, the owner thereof. That alleges a second-degree felony, which is punishable by confinement for 2 to 20 years and a fine up to $10,000. So do you understand the range of punishment?
Yes, sir.
Count number 2 is unlawful possession of a firearm by a felon. It alleges that you, having been convicted of the felony offense of evading arrest or detention with a prior conviction on March the 21st, 2013, in Bexar County, Texas, intentionally or knowingly possessed a firearm before the 5th anniversary of your release from confinement following that conviction. That alleges a 3rd-degree felony, which is punishable by confinement for 2 to 10 years, and by a fine not to exceed $10,000. So, count 2, do you understand the offense and the range of punishment?
Yes, sir.
Count 3 is an offense alleged of theft of a firearm. It's alleged that you unlawfully appropriated by acquiring or exercising control over property, a firearm from Christopher Watson, the owner thereof, without the effective consent of the owner. alleges a state jail felony, which is punishable by confinement for 180 days to 2 years and by a fine not to exceed $10,000. Count 3, do you understand what you're charged with and the range of punishment?
Yes, sir.
Okay. Count number 4 alleges the offense of criminal mischief. It's alleged that you intentionally or knowingly damaged or destroyed tangible property, windows, walls, doors, and floors of Christopher Watson's residence by shooting bullet holes into the walls, doors, floors, and breaking and shooting bullet holes into the windows of the residence without the effective consent of Christopher Watson, the owner thereof, and that you did cause pecuniary loss of $2,500 or more, but less than $30,000 to the owner. And again, that alleges a state jail felony punishable by confinement for 180 days to 2 years and $10,000 fine up to. You understand charge 4?
Yes, sir.
All right. Count number 5 is aggravated assault with a deadly weapon. It's alleged that you intentionally or knowingly threatened Harley Schindler, the complainant, with imminent bodily injury by pointing a firearm at the complainant, and that you did then and there use or exhibit a deadly weapon, a firearm, during the commission of that assault. Again, that is a second-degree felony, 2 to 20 years confinement, and a fine up to $10,000. Count number 6 alleges that you, same thing, only that you intentionally or knowingly threatened Lisa Civic by pointing a firearm at her, and that you displayed a deadly weapon, a firearm, while doing that. Again, second-degree felony, 2 to 20 years confinement, and fine up to $10,000. And finally, count number 7, also a second-degree felony, alleges that you intentionally or knowingly threatened Nathan Corker by pointing a firearm at him, and that you displayed a firearm while doing that. Second-degree felony, 2 to 20 years imprisonment, and a fine up to $10,000. So on counts 5, 6, and 7, do you understand what
Yes.
and what the range of punishment is?
Yes, sir.
Okay. Do you understand that the plea bargain agreement that you have with the state is not binding on you?
Yes, sir.
I do not have to follow it. However, if I do not follow it, I will allow you to withdraw your plea. You understand that?
Yes, sir.
You understand the flip side of that is if I do follow the plea bargain agreement that you have, and the sentence I impose is not harder on you than what you've agreed to, you will not be able to appeal this matter?
Yes, sir.
I'm going to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Plea to the Court. Let me ask you on paragraph 2.11. Is that your signature?
Yes, sir, it is.
Okay. All right. We're going to need to get the verification page signed. So let me go ahead and go through the rest of them right quick. If Mr. Leday, if you could get a clean copy of the verification page, so we're not getting another copy of this faxed copy or whatever it is, or copied copy. Let me ask you, sir, did you sign where it says trial court certification of defendant's right of appeal?
Yes, sir.
Agreed punishment recommendations.
Yes, sir.
Waiver of preservation of evidence.
Yes, sir.
And the discovery compliance certificate.
Yes, sir.
Okay. All right, we need to take a break for a moment. There's one page where it said verification that we didn't get a signature back. So I'm going to ask someone to get a clean copy of that to the jail. They should be able to just post it in chat. Actually, I can probably just post it in chat. Let me see.
They do have a clean copy because I've sent one and I've actually sent a request for them to have them re-sign that.
Oh, okay, okay. Do you have a copy of that, or do you need a copy of that?
Jason, did you send to Heather Rayner? Do they know that you've sent something?
Well, I sent the original document is there via email, the jail at Wilson.
Okay, have you contacted them to let them know to pull that one page to be signed?
I did it via chat, yes. This morning when I noticed that it was not signed.
I don't see it in chat as far as the paperwork itself.
Okay,
No, the papers at my email.
hold on.
He doesn't get your email, Jason. He's one of the bailiffs from here in our office
Oh, okay.
that just goes over there.
Right.
So we would need to contact whoever you sent the email to.
Okay, I
I'll
just
go over
posted-
and talk to the.
All right, Deputy Davis, if you'll look in your chat, I just posted a copy of just the signature page to you. And if you'll click on it, hopefully you can save it and then open it up with a Adobe Reader or something.
The Shannon file is blocked for security reasons.
All right, I tried. Yeah, y'all let me know when you have that figured out.
Judge, is it okay if I step away from my desk for a second?
Yes.
Davis, I sent a copy. See if it'll open for you.
If that doesn't work, I have a copy as well.
I've sent him a PDF that should be there. I don't know if he's trying to send us the original.
Thank you.
Cindy,
Yes.
they're sending you the page number 6 that need to be signed along with the fingerprints. Email.
Okay, I'll be watching for it. Hadn't come through yet.
Let me ask Mr. Leday, I've been looking at the offense reports and supplements. Where is the information about the burglary?
I think it is in, I gotta go back and look, Judge. It's mentioned towards the end of one of the reports in the paragraph that he had broken into a home at the location.
Okay. All right.
I think it was the person that owns the home's mother had reported let's see.
Yeah, here it is. It looks like it's
Doogie's report.
right.
And
Okay, the residence was severely damaged. Okay. So this had happened previously, and the weapon that was taken from Dotson is that weapon?
That's correct, Judge. It's the second to last page, second to last paragraph on that page. Starts with upon arriving at the sheriff's
Okay.
office.
Thank you. Okay, is that still on its way back?
Oh, I'm talking, you can't hear me. Okay, you should have it. I dropped it to you. The fingerprint page I'm worried about because it's faint. I mean, I can see the lines. I just don't know how well it's going to scan for me to send copies to TDCJ. So I may need to get the original from the jail on that. The original may scan better into my system.
Yeah, that's not usable.
Davis, can you catch another thumbprint, please? A little bit darker, but not too heavy because I need to be able to see the prints on there.
Yeah, I got 7 prints here for the,
Okay, well, find the best one and send the best one to me, please.
I'll send it real fast.
And I can go ahead and put them in the judgments. That's no problem, as long as it's clear. All right, give me just a moment. Oh, there's 7 prints. That didn't look, well, probably one of them's okay. Hold on. Yeah, no, Davis, that's fine. There's some usable prints in there. I did not realize that you'd sent all 7. I just went and looked at the first one. The first one is faint. I'm not sure Cindy had realized that either.
No, sir, I didn't. I thought it was just the first one.
All right, Mr. Dodson, on the waivers, on the page where it says verification, is this your signature? You're muted, sir.
Mr. Dotson, can you see the little microphone button at the bottom left of the screen? You're muted.
Okay.
Okay. All right. Is this your signature where it says verification?
Yes, sir.
And do you swear or affirm that everything above your signature where it says verification is true and correct?
Yes, sir.
All right. Now, did you read these documents yourself or did your attorney read them to you?
He read them to me, I think.
Okay. Well, let me ask this way. Did you understand these documents before you signed them?
Yes, sir.
Okay. And a number of your signatures are dated last week. Has anything happened since last week to make you think that you did not understand these documents?
No, sir.
And anything happened to make you want to take your signature back?
No, sir.
And are you satisfied with the work your attorney has done for you in this case?
Yes, sir.
Right. Counsel, do you believe your client is competent to, do you believe your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
He does.
And do you also believe that you've received all of the discovery you're entitled to in a timely manner?
I believe so.
All right. Okay, I'll find that the defendant made his his waivers of right knowingly, intelligently, and voluntarily, and I will approve them. And I will accept the discovery compliance certificate. And all right, give me just a moment. Ask you, sir, to the count number 1, second-degree felony offense of burglary of habitation. Do you plead guilty or not guilty?
Guilty.
Count number 2, third-degree felony of unlawful possession of a firearm by a felon. Do you plead
guilty?
Count number 3, theft of a firearm, state jail felony. Your plea is
guilty.
Count number 4, state jail felony, criminal mischief. Your plea is
guilty.
Count number 5, aggravated assault with a deadly weapon, second-degree felony. Your plea is
guilty.
Count number 6, second-degree felony, aggravated assault with a deadly weapon.
Guilty.
Count number 7, second-degree felony, aggravated assault with a deadly weapon. Your plea is
guilty.
All right. Has anyone promised you anything other than your plea bargain with the state to plead guilty?
No, I don't believe so, sir.
All right. Well, I need to ask about that. Has other than this agreement you worked out with the state on these charges, has anybody promised to do anything for you to get you to come in here and enter a plea of guilty?
No.
Has anybody harmed or threatened you or anyone close to you to get you to come in here and enter this plea of guilty?
No, sir.
Have you been promised an early release from your sentence?
What do you mean?
Has anyone promised you that you won't have to actually serve whatever sentence you receive?
No, sir.
All right. Okay, I'll find that you made your pleas voluntarily and you're not under any compulsion in making them, and I will accept them. And I'll ask what evidence the state has to substantiate the defendant's guilt.
Your Honor, we offer states 1 and its attachments.
No objections.
All right, without objection, state's exhibit number 1 and its attachments are admitted into evidence. Do both sides rest and close at guilt innocence?
Rest closed, Judge.
Defense rests and closes.
While we were on the break, I took a chance opportunity to read over the attached documents, and I'll find there is enough evidence to substantiate the defendant's guilt on all 7 cases. Both sides ready to proceed to sentencing?
State's ready, Judge.
All right.
Defense is ready.
Is there a pre-sentence investigation or a waiver of one?
We waive the PSI.
Okay, what are the plea bargains in these cases?
Your Honor, for count 1, burglary of habitation, it's 15 years TDCJ, court cost of $290 and a police officer fee of $5. For count 2, unlawful possession of a firearm by a felon, it is 10 years confinement in TDCJ. For count 3, theft of a firearm, state jail felony, confined 18 months in a state jail facility. Or criminal mischief, confinement for 18 months in a state jail facility, and restitution to Paragon subrogation of $5,871.23. Count 5, aggravated assault with deadly weapon, Count 6, ag assault with deadly weapon. Count 7, ag assault with deadly weapon. All 15 years in the TDCJ facility, and it is to run concurrent, Judge.
All right, Mr. Dotson, you heard what was read in the record by the state's attorney. Is that your plea bargain with the state?
Yes, sir. The 15 years?
Yes, sir. Did this plus court costs plus the restitution?
Yes, sir.
All right. Did the state's attorney add anything or leave anything out? Was there anything else that should have been part of your agreement that Mr. Leday did not read?
Sir?
Was there anything else that was supposed to be part of your agreement that Mr. Leday did not read into the record?
No, no, sir.
Did he read anything into the record that was not part of your agreement?
No, sir.
Okay. Anything else from either side?
Not from state.
Nothing from defense.
And how many days credit is Mr. Dotson entitled to?
Judge, let me pull up that judgment.
I guess I have.
14 months. Somewhere around about.
Let's see, Judge, I have 489 total days.
All right, Mr. Dotson, is that what you believe you're entitled to?
Yes, sir.
Okay.
How many months is that, if you don't mind me asking?
13 plus.
Okay.
All right. Anything else from either side?
Not from state, Judge.
Nothing from defense.
Okay. I'll find that I have enough evidence to make a decision in this case without a precedence investigation. I will follow the plea bargain agreement in this case. I'll find you guilty of all 7 offenses in counts 1, 5, 6, and 7 second-degree felonies. I'll sentence you to 15 years confinement. And in count number 2, I will sentence you to 10 years confinement. And in count numbers 3 and 4, I will sentence you to 18 months confinement, plus court cost and the restitution due in the criminal mischief case of 5871-23. All right. Is there any legal reason why sentence should not now be pronounced?
No, Your Honor.
All right. It's the order, judgment, decree of the court that you be taken by the sheriff of Wilson County and transported to the authorized receiving agent in the Department of Criminal Justice. You'll be confined for a period of 15 years in counts 1, 6, and 7, for 10 years in counts 15 years in counts 1, 5, 6, and 7, for 10 years in count 2, and for 18 months in counts 3 and 4. These sentences will run concurrently with any other sentence you may be under, and you'll receive credit for all of the time you have spent so far in jail on these charges. You understand, sir, that because I have followed the plea bargain agreement that you have with the state in this case, that you have waived the right to appeal and you may not appeal?
Yes, sir.
All right. Okay, I'll find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them, and I will certify to the Court of Appeals that you have waived the right to appeal and you may not appeal. Wish you good luck, sir. Give me just a moment. I'll get this done on the judgments. All right, this is going to take a few minutes. Let's take a break till 10:45, and then I'll come back and I'll see where we stand on the other cases.
What time is it now?
Mr. Dawes wanted a breakout room with his client Nicholas Moreno, who's in jail. I guess once the jail's finished with Mr. Dodson, if y'all can bring Moreno.
I'll bring Moreno right in. Let me go get him out when I take him back.
Thank you, sir.
Mhm.
Mr. Dawes, you're there, right?
Yes.
Okay. They're gonna go get him so I can put you in a breakout room here in a moment, okay? As soon as he gets here. I'll put
Thank
y'all in
you.
breakout room 6, okay?
Okay, thanks.
You're welcome.
I have Nicholas Moreno here for you.
Thank you. I'm gonna put y'all in breakout room 6, if you can accept that, please.
Thanks.
Your Honor, he's in custody, and I believe Mr. Barrera.
Ms. Riley?
All right, ladies and gentlemen, I just sent, I believe, all 7 judgments and the withholding attachment to Ms. Sawyers. I will be back in a few minutes.
Mr. Sean Keen Dawes, can you go back to room 6 and then I can ask Mark Lede to join you there?
Okay, thank you.
You're welcome. And Mr. Lede, did you hear me? I'm not sure if you're there. I don't see you, but.
Lori,
Yes,
Mark is headed back to his office.
okay. Thank you.
You're welcome.
Judge Wilson, I don't know if you're in the courtroom and can hear me, but do you have the plea packet on Stephen Dotson?
Mr. Dawes, is Dennis Smith also in jail? Okay, let me ask the jail to bring him over.
Yes, he's in jail.
Okay. Wilson County Jail, can y'all bring Dennis Lee Smith so Mr. Dawes can speak to him?
Yes, I'll get him pulled.
Thank you so much.
All right, ladies and gentlemen, let's go back through the dockets and see where we stand. We'll start with the criminal dockets. You have the attorneys, yes? All right, David Greenwood. Apparently I have something been sent to me.
We filed a motion and we have a proposed order that grants or denies the motion, but that's all we would have sent, Judge.
Okay. Dennis Smith, Nicholas Marie.
Yeah, we have a offer from the state. I need to communicate it to the client. So that will be reset, Your Honor.
All right, I think settles. Does she have that person have a new date?
Yes, Your Honor, 4/21, Your Honor.
All right, and Gregory Hobson
is reset to 4/26 to plea.
Pavlik, we get a date?
Your Honor, I have May 3rd.
Cnty?
5/3, Your Honor.
Antonio Morales?
I had 4/21 on Nicholas Puente.
I do also. That's what I show he
Oh,
posted to everyone was 4/21.
Yeah, 4/21. I'm sorry. Yep.
Okay.
Slip of the tongue.
Antonio Morales is my case, Your Honor. I'd like to make a motion to reduce the bond. Maybe hear that.
All right, I'll let you. Has it been filed?
It has not yet been filed.
Okay. So we'll come back to that. Sean Spalding.
That's still sentencing, Judge.
And how long to hear the sentencing?
I have one witness, maybe 20, 30 minutes. I'm not sure about Mr. Keedaw's.
I would agree with to that, Your Honor.
All right, Mr. Keedaw's, that's in total or?
I would say total. I would say 30 minutes total. Because, he should have his wife as a witness, but I mean, it shouldn't be very long.
All right, and what date do we get for Mr. Bauer?
6/22, Your Honor.
Oh, that is the end of it. And the add-on.
We pled.
It's a final judgment.
Yes, sir. I still need the plea packet signed from you. You sent all the judgments, but not the plea
Mhm.
packet.
Okay. It shows it went through.
Thank you. It is here.
All right, on the civil cases, we have a judgment in ovation. Hold on, that's not the first page, though. All right, in the interest of Madison Balmos, are they still conferring?
Yes, they're still in a breakout room, Judge.
All right. BDW, a child, still at 20 minutes. Yes, so I'm sorry, Mr. Garcia.
And Wilson County Jail and Mr. Sean King Dawes, if y'all can go to breakout room 7, please.
Okay, on Rose, I just signed that judgment. Is Ms. Tejada still on? There she is.
Ovation
I'm here,
versus
Judge.
Rose, Your Honor? Was that on Ovation versus Stephen Rose?
Yes, I just posted that final judgment to the court, to clerk, Ms. Tejada.
Thank you, Your Honor. May we be excused?
Yes.
Thank you, Your Honor. Thank you, Your Honor.
Yes, sir. Have a good day. All right, so let me look at the pre-sentence investigation. Well, actually, Mr. Barrera, yours might be quicker. All right, that's Nicholas Moreno.
Waiver of service, specific waiver, it says to the respondent, without the advice and help of an attorney, you may be putting yourself or your property
All right, calling State versus David Greenwood. Are both sides ready?
State's ready to proceed, Your Honor.
Defense is ready to proceed, Your Honor.
Go ahead, sir.
Your Honor, all we have before the court today is a motion to modify conditions of release. Previously, this court ordered that while out on bond on his case, Mr. Greenwood be required to have a GPS ankle monitor. We're just asking the court today for the authority for Mr. Greenwood to remove that monitor due to the cost of maintaining that monitor. I have two witnesses to present to the court on this issue, Judge.
Are they both here?
They are, Your Honor.
All right, their names are?
Kayla Jansen.
Okay.
And Andrew Flores.
Will each of you raise your right hands? All right, do each of you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
I do.
All right, thank you. Go ahead, Mr. Barrera. The defense would call Kayla Jansen to testify, Judge.
Go ahead.
Good morning, Ms. Jansen.
Good morning.
Can you spell your name for the court reporter, please?
Kayla Janson.
Thank you. Ms. Jansen, are you familiar with David Greenwood?
Yes, sir.
How are you familiar with Mr. Greenwood?
Boyfriend, we're having a baby.
You all are having a baby together?
Yes.
Do you all cohabitate?
Yes. Yes.
You live together?
Yes.
How long have you all lived together for?
About 6 months.
Okay. Are you aware of Mr. Greenwood's current financial situation?
Yes, sir.
Where does Mr. Greenwood work?
I don't.
Okay,
He's a welder.
Ms. Jansen.
Yes, sir.
Okay, so when I ask you questions, just testify about stuff that you know. On camera, it looks like you're looking off to the side, communicating with someone. That's not what we're doing during this hearing. Do you understand?
Yes, sir.
Okay, just answer stuff. I'm gonna ask you a question. You testify as to your knowledge. If you don't have knowledge, you can say, I don't know, okay?
Yes, sir.
But this is your testimony. This is not the testimony of any other person. That's why you're being called to testify. You understand
Okay,
that?
yes, sir.
Okay, all right. So let's start again. Where does Mr. Greenwood work?
He's a welder. That's all I know.
Okay. And so he's currently employed as a welder?
Yes.
Is that a full-time job?
Yes.
Okay. How many hours a week does he work, more or less? Do you know his schedule?
No.
Okay. When you say it's a full-time job, is it somewhere in the neighborhood of 40 hours a week?
Yes, a little under.
A little under. Okay. And when you say a little under, does he have a typical schedule that he works?
He usually goes in from about 7 to like 3.
Okay, so 7 a.m. to 3 p.m.?
Yes, sir.
Is that Monday through Friday?
Yes, sir.
Okay. Now, do you know how much he makes in his employment as a welder?
It's about $700 every 2 weeks.
Okay. So every 2 weeks, he receives about $700?
Yes, sir.
Okay. So that's roughly $1,400 a month, more or less?
Yes, sir.
Okay. Out of that $1,400 a month, what bills do you guys have?
Our cost of our children, diapers, formula, food. We have our rent, phone bills.
Okay, so let's talk about that. Where do you guys reside?
We live with my aunt.
Okay, and do you pay rent to your aunt?
Yes.
How much rent do you pay to your aunt?
200.
200 a month?
Mm-hmm.
Okay. And you said that you all have, do you pay any kind of electric, water, anything like that, or is that included in the rent?
That's included.
Okay. Do you all have any kind of phone bill?
Yes.
What is the amount of the phone bill?
Like 50.
$50 a month. Do you each have a phone, or is this just for one phone?
It's just for one.
Okay. Now David is out on bond. Does he make any payments towards that bond? Are you aware?
Yes, but I'm not sure how much.
Okay. What about in terms of food and things like that? What do you all pay?
It's probably like $350 a month.
$350 a month in food. Okay. And then you said our kids, how many kids are there?
2.
2 kids. How does that include, because are you pregnant right now, or
I'm pregnant, yes.
you are pregnant? Okay,
But we
so
have 2 kids at home, yes.
2 kids at home. Okay. And the 2 kids at home, what are the expenses related to them?
Diapers, formula, clothes, wipies.
Okay. Now, is David the biological father of those children?
No,
Okay. Do you receive child support for those children?
no.
In terms of the child that you are expecting, how far along are you?
20 weeks.
Okay. So the, I guess, expected delivery date would be more or less when?
August 17th.
How often are you seeing the doctor?
Every 3 weeks, every 4 weeks.
Okay. Are there expenses related to that?
No, sir.
Who covers that?
Medicaid.
Okay. With regard to the delivery, do you know if that's something that Medicaid is going to cover?
Yes, sir.
Okay. Now, when David, in terms of getting to work every day, how does he get to work?
I take him.
You take him? Okay, and this is your vehicle?
Yes.
And who pays for the gas for that vehicle?
David.
Are you working right now, Ms. Jansen?
No, sir.
Okay, so David's income is the only income.
Yes, sir.
At the end of the month, after you guys pay all of your bills, how much do you guys have left?
Probably like $200.
Okay, and that's after everything is paid?
Yes, sir.
And David is currently paying on his GPS ankle monitor.
Yes, sir.
Okay, so if after everything is paid, you have $200 left at the end of every month, are you expecting your finances to change, or how is it that you guys can't afford it if you're affording it now?
I mean, we're barely affording it.
You're barely affording it. Okay.
Yeah.
Okay. I understand. And I understand having $200 at the end of the month is not a lot that's left, but is there any expected increase in bills you're going to pay or anything like that?
A second vehicle and possibly getting a house of our own. Yeah.
Well, that's not going to be a concern for the court, but let me ask you this. What about the baby when the baby comes? Are there expected to be any increased payments or bills or anything like that associated with this new baby?
I mean, we'll have a third child in diapers, so that'll go up. The cost of formula for 2 kids.
Okay. And is this why you're coming before the court today? Because of that expected expense?
Yes, sir.
Okay. I'll pass the witness.
I have no questions, Your Honor.
The next witness.
Andrew Flores.
Go ahead, sir.
Mr. Flores, are you familiar with David Greenwood?
Yes,
How are you familiar with him?
I supervise him under bond supervision.
How long have you been supervising him?
Since the beginning, since August of 2018, more recently since September of 20.
Okay, so Mr. Greenwood has been in and out of custody depending on the status of his bond on this case, correct?
Yes.
Okay. Since he's been out in September of 2020, which was roughly 6 or 7 months ago. Have you had any issues with him?
No, I haven't had any positive UAs. He had 2 interlock violations, but they were for medical reasons. He provided me a note from the doctor, and I did verify the GPS that he went to the doctor and back.
Okay. Since the time that you've had him on the GPS monitor, has he violated any of those conditions?
Not since September.
Okay. And so when you say not since September, did he have GPS ankle monitor violations prior to that?
Yes, not a GPS.
Not GPS. His violations had more to do with a substance in his system, correct?
Yes.
Substance. Okay. But since the time he's been out in August of 2018, there have not been issues in terms of him being somewhere where he's not supposed to be, or violating any restrictions related to his GPS ankle monitor?
No.
How often does he report to you?
He reports weekly for UAs and direct office visit once a month.
Okay. And does he make those appointments?
Yes.
I'll pass the witness.
Just a couple of very quick questions, Your Honor, if I may proceed.
Go ahead.
Mr. Flores, you mentioned how many times has Mr. Greenwood been revoked off of his bond?
Twice, I believe.
Okay. And he is currently he is up to date on his GPS fees as of today?
As far as I know, yes.
Thank you. I pass the witness.
And do you recall the basis, Mr. Flores, of the previous bond revocation?
Primarily or both due to meth use.
To meth use. And that is something you're testing him for as part of his weekly drug tests?
Yes.
I'll pass the witness, Judge.
I have no further questions, Your Honor.
I have no other witnesses for the court, Your Honor.
Okay, what do we have? Any witnesses from the state?
No witnesses from the state, Your Honor. Just a minute.
Go ahead. Argument.
Your Honor, just Mr. Greenwood has been out on bond since August of 2018. There have been these interim periods where he had revocations and would go back into custody. Those were related to positive UAs. He reports to probation for drug testing once a week. He can continue to do that without an ankle monitor, Judge. He has not had any violations relating to him being somewhere where he is not supposed to be. We're asking, in light of his financial situation, that the court consider allowing him to remove the ankle monitor. I know we may be a couple of months premature because the baby is not here yet, but even in their current financial situation, you heard the testimony of Ms. Jansen that they're barely getting by. We would ask the court, in light of the fact that he is abiding by his conditions, to take away that financial burden of that GPS ankle monitor, Judge.
Ms. Whitney.
Thank you, Your Honor. Your Honor, the offense, Mr. Greenwood's been charged with murder. The offense alone kind of speaks to why he needs to have a GPS monitor on. The other, as this court has previously heard in prior bond hearings, Mr. Greenwood fled to another county, was arrested in a different county, which definitely stresses that he is a flight risk. His bond has been revoked twice previously, Your Honor, and as of right now, he is paying his GPS fee. So right now, that is not an issue. That is one of the things he knew when he would get out on bonds, he'd have to pay the GPS fee. Your Honor, given all of this and the fact that this is a very serious, it's a first degree offense, we would ask that that monitor stay in place at this time.
All right, Mr. Flores, would you give me a thumbnail sketch of how the GPS monitoring works as far as what reports do you get?
Yes, Your Honor. So I get a monthly report, but also if there's a violation report, for example, when he had went to the hospital, I get an immediate email that there's a violation. And then I can look at it and see in detail where he's at.
And what does the monthly report look like? Does it send you a map or?
No, we get a general monthly one via email, but I have access to look at specifically every day. The monthly report just indicates if there's any kind of violations, but I get a daily report almost. Actually, I do get a daily report, but most of the time there's no violations or anything on there.
Okay, and by what does that daily report? Does it just say no violations, or does it say he was here at this time and then went somewhere else?
Pretty much. I mean, there's different issues. They'll sometimes have a charging violation or so if it's not charged fully. Different alerts that it'll let me know. But the main one is because he has a geographical area to the county and surrounding, I believe. And so if he goes outside of that, then it notifies me.
Okay. All right, anything else on either side?
Nothing further.
Okay, I will agree with Mr. Barrera that the motion is at least premature. I will deny it, but I will also tell him and his client, I don't know what sort of tracking apps are available for cell phones. I'm not certain what sort of phone Mr. Greenwood has. I know that with my phone, which is an iPhone, you can have a thumb to open it up. What I would consider some months from now, if there continues to be good compliance, is that if there is a tracking app for whatever sort of phone Mr. Greenwood has that would automatically send reports to Mr. Flores, and if it's possible, Mr. Flores goes in to, when Mr. Greenwood goes into Mr. Flores for his weekly testing, to have Mr. Flores reset the password so that David Greenwood doesn't have the password to his computer, to his phone, and the only way he can open it up is with his thumbprint. So that, and with the idea that, you know, he could be called at any time and he'd better answer the phone so that we know that it's with him. I'm not saying I would go with it, whatever, but I would consider something along those lines. Where if we saw the phone was going about Mr. Greenwood's business, and if he was just called at random, if he's the only one that can answer it with his thumbprint, and that he can't open it up, or let anybody else open it up unless they cut his thumb off, I would consider that. So for right now, though, I will deny the motion.
Thank you, Your Honor. We'll look into that. Thank you, Judge.
Judge, do you mind if I say one thing?
Yes, Mr. Greenwood, you need to address that to your attorney. If Mr. Barrera thinks that that's something that I need to know about, then he will make sure that it's relayed to me in court.
Judge, I will confer with my client, but that's all we have for today.
All right, you are excused if you wish to be.
Thank you.
Your Honor, Anthony Bancroft, I've returned from the other court.
Okay.
It's on the Walpole matter.
All right, give me just a moment. Let me get this posted to the clerk. All right, Ms. Sawyer, I've just sent that to you. All right, Mr. Bancroft, what case are you here on?
Your Honor, Ms. Mazahari and I were on the interest of Brooklyn Walpole. We had
Okay,
it on
yes.
15 to 20 minutes.
Okay. All right. And is Ms. Mazahiri here?
She said she was going to come back and stand by until I got back. I will text
Here
her
she
right
is.
now.
I'm asking her to unmute. Here she is. All right, and did y'all have an opportunity to confer or?
Yes, Your Honor, we have conferred. Let's see, what do we have here? We have the agreed order for the forensic evaluation signed by the parties. I can submit, I guess, by e-filing and then ask for someone to get it and get it to you.
If you could just post that to me in chat, if you have it in a PDF format, that would be better.
I will do my very best, Judge.
Okay, if you'll just click on my name or even everyone in chat, and then it should pop up unless you're on a little tablet or an iPhone or.
Oh, okay. I can, yes, sir. I can actually scan. I think I could scan it. Yes, file, connect the file. Yes, I'll do that. With respect to the motion to compel discovery, that's still a live motion. And then with respect to the motion to appoint reunification therapist, that is also a live pleading as well. That's where the 15 to 20 minutes is going to come from, Judge.
Okay, let me go back and look. I think we may have one thing shorter. Maybe not. All right, TRLA on the bond for Mr. Moreno. How long were you announcing on that?
Your Honor, on that one, we don't have the witnesses. I already conferred with Mark, so I'm resetting this for, I'm sorry, I'm resetting this for the 19th.
Okay, 419.
And that's in the chat.
All right, thank you. Anything else? Have anything short ready to go?
We're ready on, we're ready on Mr. Spaulding.
All right, that's half hour.
Right.
Okay. Okay, we're going to go ahead and take up the civil matter first. It's supposed to be shorter. Does anyone want to send me a copy of whatever motions it is that I need to be looking at? On this case? The Balmus child?
Judge, I don't see Grace on here. She might be in a breakout room.
Oh, not Balmus. BDW. I don't even know who this is. 13-12-721. Ms. Bancroft, Ms. Mazahiri, do you have a copy of your file of your motions? Or
Yes, Judge, I do.
post those in-
We have CVW 13-00-721 in the interest of BW, a child, Brooklyn Walpole.
Yes. All right. If y'all could post that to me in chat, someone.
I have it scanned in now, Judge, and now I'm trying to rename it. So let's see here, desktop, there we go. Okay, Your Honor, I believe that I have uploaded it. It's titled Walpole Agreed Order.
Okay, and whatever live pleadings I need to look at. If you have those, I'd appreciate it.
Give me just a second, Judge.
Judge,
Yes.
this is the jail. I believe we're finished over here. Are we excused?
Why don't, where is Mr. Spalding in custody?
I think they said he was at probation, Judge.
Probation, okay.
He is here at probation, Your Honor.
And
All right.
Morales.
I mean, if you're finished, that's great. You're finished, you're excused.
Your Honor, Antonio Morales is in the jail.
Okay, all right, so are you still need to talk with him? I don't understand what that means.
Well, I would like to hear I filed the motion for, to reduce bond, and if the state doesn't object, I'd like to go forward with that today.
Okay. What says the state?
No objection, Judge. We'll go forward.
All right, well then, please get Mr. Moreno there.
Morales.
Antonio Morales, and we'll take that up after the civil hearing. All right. And Ms. Mazahiri, Mr. Bancroft, what part of the family code, what section talks about reunification coordinators or facilitators?
I believe, taking a stab at it, Your Honor, it's going to be under 154. The child has not had any relationship or contact with the father for the last 9 months, and we believe that in the best interest, I believe in the best interest of the child, it would be appropriate for this. There's some other things that have caused the 9-month break that we can talk about.
All right, let me.
And Judge, my position is I don't believe the family code directly talks about reunification therapy at all. The child has a psychologist, and the psychologist says that child is suffering from PTSD.
Okay, and I just wanted to know if there was a specific section I need to be looking at, because I typed in reunification and everything I found was having to do with CPS.
You are correct, Judge. There is no specific section for non-CPS cases.
Okay. All right, so are both sides ready?
Yes.
Yes, Your Honor.
All right. All right, now I have two amended motion for appointment of forensic therapist. It looks like it's the same thing, the same document.
It very well could be. I'm not sure what Ms. Mazahari submitted, Your Honor, but
Okay, y'all may have.
yeah, the motion for forensic evaluation was signed by myself, Ms. Mazahari, appointing Dr. Richard Tice as the evaluator.
Yes, and I've already sent that back to y'all. Okay, go ahead, Mr. Bancroft.
Your Honor, my brief opening is this, is with respect to the discovery matters, we had properly requested discovery. The answers were due and provided to us on time in March of 2020. Contained in those requests for discovery were...
Okay, and Mr. Bancroft, let me interrupt you. I found out what the issue is. I don't know how it came over, but right now, I received the amended motion for appointment of a forensic therapist. Under that name and under the motion to compel, I received the same document with a different name. Received 2 copies.
I have sent you an amended motion for appointment of forensic therapist to perform reunification.
I have 2 copies of that.
I did not send that to you, Judge.
All right, it says Anthony Bancroft to me, 11/25. All right, do I need to see a copy of your motion to compel?
Oh, I see. Okay, I see what I did, Judge. The motion to compel is what you're not having.
Yes. I've got a document that says it's that, but it's another copy of the motion to appoint.
Let me rectify that, Judge. I apologize for the inefficiency. All right, Judge, I think I fixed it this time.
All right, give me just a moment. Okay, go ahead, sir.
Okay, Your Honor, with respect to the motion to compel, discovery was asked for and received timely in late March of 2020. And contained in the responses was the will supplement moniker. And up to date, Your Honor, we have not received the supplementation until this morning. Part of my request in the original discovery was that I want the text messages between the mother and daughter and mother and another gentleman. And in lieu of such text messages, I would ask for an authorization to release information so I can procure them myself. That matter has partially been resolved because we have received some text messages, but I need the release of information so I can do my due diligence and double check to make sure that certain messages were not deleted. Continuing with my opening statement, Your Honor, with respect to reunification therapy, Your Honor, there's a CPS involvement in this case. This case was closed in 2020. The only reason and purpose behind my client not having a relationship or seeing his child is due to the direct acts of the mother. We came to court last fall, Your Honor, and we agreed that until we got into court and resolved some matters that my client would have zero contact with the child. But our motion for enforcement is still live. So the best way to resolve it was the forensic evaluation for mom and dad through Dr. Tice. And then since it's been 9 months and my client has had absolutely zero contact with his child, my client is motioning the court to appoint a reunification therapist to begin the process. At some point in time, Judge, this child is going to have a relationship with the father. My client is willing to testify to facts and circumstances that were actually heard by you in December of 2019 when we had another modification hearing. And with that, Your Honor, I think that would be the summation of it before I call Mr. Walpole.
All right, Ms. Massahari.
Judge, we were before you in November, and at that time we agreed to no contact. We also agreed that both parties will have psychological evaluations with Dr. Tice, and Dad will have an alcohol assessment. Here we are 9 months later. He hasn't done his part, but he wants the court to do something more for him. This child is suffering from PTSD from Dad's acts. Child's therapist does not believe the child is ready for any kind of reunification, so we ask the court not to order any reunification therapy at this time. Should the court decide to order reunification therapy, then we ask the order be specific that that therapist talks to the child's therapist and makes sure that nothing is being done to harm the child. It's really important if another therapist were to come on this case to hear from the child's therapist that the child has been seeing since 2015. As far as the authorization to release information, Mr. Bancroft is correct. We did supplement with some text messages this morning. The incident involving Dad inappropriately touching the child in her panties happened in June of 2020. They want an authorization to release phone messages from January of 2020. We think this is simply a fishing expedition. We've already provided what we have. We are missing some months from communications between my client and and Dad's girlfriend's ex-husband. My client only has those from October, but the ex-husband has those messages going further back, and we've offered to provide those. I think there's a good reason for the court to deny any kind of release. This is just a fishing expedition.
All right, your first witness, sir.
Your Honor, at this time, I'd like to call Sheldon Walpole.
All right, let me ask both of you to raise their right hands. Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your names for the record?
Sheldon Walpole.
And Laura Walpole.
I'm sorry?
Laura Walpole.
Still can't hear.
Laura Walpole.
All right. Go ahead, Mr. Bancroft.
Mr. Walpole, with respect to the discovery matters, we need to give the court a little bit of background history. Why is it that you specifically want to see the text messages from 2020 up to and past the allegation that is at hand?
Because I believe that there was some collusion with that because the accusations are completely false. And I believe that that was something that was put on me.
And with respect to the history of this case, have you ever had an experience where evidence and testimony was presented with respect to the mother texting the daughter and suggesting or requiring things from the daughter?
Objection leading and raised judicata.
Your Honor, evidence.
Suggest that as to anything from before the last hearing. I don't believe we can go back before that.
Your Honor, I believe that res judicata would apply with respect to conservatorship and access, the facts and circumstances belonging there. We're talking about evidence that was admitted and heard at trial on December the 19th, 2019.
Right, Ms. Mazahiri?
Same objection, Judge. It's raised judicata. The evidence has already been heard and the question was leading.
I'll overrule both objections.
Mr. Walpole, do you have reason to believe that this has occurred before?
Yes, I do.
And when, can you briefly explain to the court what you discovered through evidence and testimony?
We found text messages on my daughter's phone that was Laura asking her to take pictures and of my trash cans in my truck, of any alcohol type stuff or anything that might get.
No, but the witness testifying about a
Okay, ma'am, I can't hear you. Are you have multiple electronic devices there, or?
I do not, Judge.
And I can hear you there. All right. Your objection?
Objection to witness testifying about or document not introduced into evidence. He's basically trying to tell you what a text message says.
Your Honor, if I may respond, a lay witness is permitted to testify evidence from their personal knowledge. And I believe the question was framed as such. Do you have any reason to believe? And he was testifying, therefore, from his personal knowledge, and it should be admitted.
I'll overrule that objection.
Mr. Walpole, go ahead and finish your statement, sir, with respect to pictures, trash cans, whatnot.
Right. It was sent on the text messages from her mom to take pictures of any evidence that she can get against me, as far as any kind of beer can, alcohol stuff, or anything else that would make me look bad. And she sent her some pictures, which y'all had before, and then says, okay, now delete this so your dad doesn't see it.
Okay. And with respect to the current allegation.
All right. Does someone have two electronic devices going at the same time?
I don't.
I don't.
Right. Okay. Maybe it's just Zoom today. Go ahead, sir.
Train of thought here. So moving forward to the current allegation, is it your testimony that this relationship between mother and daughter and father and you and your daughter, it's been contentious the entire time? Is that accurate?
Yes, it is.
Has Laura Walpole attempted to take away your possession and access before?
Yes.
And do you believe that this was just another attempt at affecting that relationship?
Yes, I do.
Do you have any personal knowledge of your time spent with Laura Walpole where this has been consistent behavior with other children and their fathers?
Objection,
Yes.
relevance.
Your Honor, it goes to the
I've already overruled it. Go ahead.
Okay. Go ahead, Mr. Walpole. Answer the question.
Yeah, she has 3 children with 3 other men, and she's done the exact same thing and destroyed their lives destroyed their relationships with each of the other fathers, just like she's doing to me right now.
All right. So therefore, the text messages we presently have,
Mr. Bancroft, I can't hear you. I don't know what you're hearing on your end, and I'm not saying it's your fault. It just because it was Ms. Mazahiri a minute ago. We keep getting that echo.
Maybe if Ms. Mazahiri muted, or if I blank the video on my end, might help, Judge. You can still hear my face.
All right, she's muted. I'm not sure, but go ahead.
Is this any better, Your Honor?
Well, yes, but it's not consistent. It just goes in and out. So go
I'm
ahead.
going to stop the video, but try this. How about this, Judge? Is this better?
Well, I don't think the video has anything to do with it, but go ahead. It was not consistent. You just come in and out. So go ahead, sir.
All right. Mr. Walpole, are you asking the court to issue an order for a release of information that it be so narrowly tailored that it only involves communications between mother and daughter and mother and Roy Good for the 12-month period of 2020?
Yes, sir.
And what is the purpose for that release of information? What do you want to safeguard or check against?
Not really sure how to say it, but basically the plotting against me to take my daughter from me.
And the evidence that we received this morning, the evidence that we just received.
Mr. Bancroft, because it. You repeat that, sir?
Yes. The evidence received this morning, are you intending to compare what you can receive from the telephone company versus what was produced?
Yes.
Very well. With respect to the motion for reunification, you have agreed to, both you and Ms. Walpole, to attend Dr. Theis and be evaluated for drug and alcohol issues and all that sort of stuff. Is that correct?
Yes, it is.
And is it your intention that you continue to be willing to do so?
Yes.
And up to today, are you aware of why that was not done? Did you interfere or not cooperate?
Not at all. The last I was told on the entire thing is I was waiting for Dr. Theis was supposed to get a hold of me. And I called his office or the number that I had for him several months ago and left a message, but I've never got anything since then.
So you're still going to go through it.
I'll do anything I'm told to do to get my daughter.
All right.
All right. And then now
I need you to repeat that, and I'm going to mute Mr. Walpole. And Mr. Walpole, and I don't know what's going on, but we'll just try to, until we mute everybody. I'm going to mute myself. Okay. If you're not actually answering the question, Mr. Walpole, remain muted.
So with respect to the reunification request, you're asking the court to appoint the reunification to, I guess, simultaneously work towards your visitation and possession with your daughter. Is that your goal?
Yes, it is.
Is there anything in writing by CPS, the state of Texas, like the sheriff's office, that says that you cannot have any access to your child?
No, there is not.
And your agreement in November of 2020 to not have any contact with your child was based upon your belief of reunification occurring?
That's exactly it.
And the longer this drags out past 9 months, you're still not receiving any contact with your daughter.
That's correct.
Do you believe that this is some sort of, I guess, legal means of preventing you to being with your daughter?
That's exactly right.
And you understand the reunification therapy is a process that does not occur overnight.
I do, but I still need to get started.
Agreed. Very well. I'll pass the witness, Judge.
Go ahead, Ms. Mazahiri.
Thank you, Judge. Mr. Walpole, is it your testimony that Laura caused you to put your hand down your daughter's panties?
I did not put my hand down my daughter's panties.
Well, you have maintained that you were asleep and you don't know what you did. Isn't that true?
I have 2 other witnesses that were right there with us that also say I did nothing wrong. And I couldn't have possibly reached that far anyway.
Your daughter has said that you put your hand down her panties, didn't she?
I haven't even seen the whole thing.
You have not watched the child safe video?
I have not been provided it, no.
Who's your child's therapist?
I'm assuming still Diane Way.
When's the last time you spoke to Dr. Way?
I don't have the exact date, but I had an appointment with her.
Have you had an appointment with her since we were last in court in November of 2020?
Only once.
Now, when we were in court in November of 2020, you agreed to no contact with your daughter, and we agreed to not go forward with the protective order that Wilson County had filed against you, didn't we?
Yes.
What has changed in the last 9 months that you feel this court should now force your child into reunification therapy?
Nothing's changed, but she's still my daughter.
Do you understand that she's traumatized?
Well, after all the cops and everything she had here that night watching her dad get thrown in that cop car, I'd imagine she is.
Do you know that Dr. Way has diagnosed her with PTSD from sexual abuse?
I was not aware of that.
Having known that now, do you still think someone who's suffering PTSD should be forced to reunify with the person who caused the PTSD?
I did nothing to cause that girl PTSD.
Pass the witness.
Briefly, Your Honor, Mr. Walpole, were you ever charged formally, if you know, with respect to sexual assault of a child?
No, sir.
All right. Do you know, from your personal knowledge, whether or not the case was even filed with the district attorney's office?
No, it was not filed.
And do you know why it wasn't filed?
Because the investigator didn't feel like anything was done wrong.
And it's been suggested that you were sleeping when this allegation allegedly occurred?
Yes.
Do you don't know what your daughter has said to anybody? Is that true?
Yes, it is.
And it's because you've had zero contact with your daughter. Is that correct?
That's correct.
Right. And again, it's your position that this is some sort of legal meandering by Laura Walpole to finally sever your relationship with this child.
Yes, it is.
How many times have you been involved with CPS and the court system where Laura Walpole has attempted to prevent you from seeing your child?
I honestly don't even know the number.
Can you give an idea to the court of how significant it has been?
What do you mean?
Like, has it been one occasion where CPS has showed up to your house, or one time that you've reappeared in court to modify things?
No, this has been an ongoing thing ever since our divorce.
And when was your divorce?
In 2014, I believe.
So for the last, what would that be, 7 years?
Yes.
Fair enough. No questions, Judge. Thank you.
Briefly, Your Honor.
Go ahead.
Mr. Walpole, isn't it true that the investigators said they're not charging you because your daughter said you were snoring while your hand was in her panties, therefore they could not prove intent?
No, that's partly true, yes.
And isn't it true that you've had at least 2 DWIs since 2019?
That is not true. I've never had a DUI.
Have you been drinking and driving? Is that a complaint your daughter made?
No.
Isn't it true that the pictures you testified earlier that your daughter was taking was of alcohol containers and bottles?
It was a whiskey bottle that I was taking to the guy that owns the ranch that we hunt on.
Pass the witness.
Mr. Walpole, with respect to that whiskey bottle, do you recall the court's finding about that whiskey bottle?
Basically, that there wasn't nothing wrong with it and it wasn't illegal.
Was the bottle open or closed, according to the court?
It was closed.
No further questions, Judge.
Ms. Mazahari?
Nothing further.
All right, Mr. Bancroft, your next witness.
Your Honor, if I would briefly call Laura Walpole.
Go ahead.
Ms. Walpole, with respect to the therapy, is it not correct that the current order says that you shall set the appointments with Dr. Way and give Sheldon Walpole 14 days notice?
Correct.
Right. How many appointments have you made, and how many times have you made them and given Sheldon notice?
In what time frame?
Up till now, since I guess 2019 when that order was placed.
When the order was placed, I had made several appointments. 2 of them, I believe, I have to look, but I think it was 2 of them that he was unable to make. One for sure because he had a business meeting. He did attend one, but since the incident, June 10th, I have not notified him. because of what he's done to our daughter.
And how did you communicate these appointments and dates and times for Mr. Walpole?
Through the app we use, App Close.
So then you said several appointments were made and potentially broken for whatever reason or another. And that should all be contained on, what is it, App Close or Our Family Wizard, whatever that's called?
Yeah, I do know that, let me think, hold on. From the time we were at court last, I don't know the exact, I would say probably 4 months that we tried to schedule appointments. Like I said, Sheldon did make one. He couldn't make the one in May. And then, but because there was a time that we were trying to let Sheldon just schedule the appointments himself without having to have me do everything for him. But he refused to return calls back to Diane Way.
Okay, but so there's some evidence there, at least 4 times.
Yes, I would assume about that, yes.
Okay. And you're taking Brooklyn to Dr. Way. You present the child to Dr. Way. You provide whatever reason for being there to Dr. Way. Is all that accurate thus far?
Yeah.
Okay. And then once the doctor's there, the doctor basically begins to work with Brooklyn based upon the narrative that you've provided.
No.
How else would she know why you're there?
It's based on what the child or what Brooke is saying, not what I'm saying.
How many times have you been involved with CPS and Sheldon and been to court with Sheldon over the last 6 years?
CPS, 3 total.
Okay. And in court, how many attempts have you tried? How many attempts at changing conservatorship have you attempted?
I'm free. Can you say that again, please?
No, I apologize. How many times have you attempted to change conservatorship or affect his possession of Brooklyn in the courts?
I don't remember.
You must remember, ma'am, unless it's been so many you can't remember.
No, there hasn't been.
So was it one time?
That I've tried to take conservatorship at Brooke?
Change conservatorship or affect his possession. How many times has it occurred?
I don't know.
Okay. Would you agree that if you changed it one time or attempted one time that you could remember one?
Yeah.
Would you agree that if it had been twice that you've spent money on an attorney in say 6 years that you could remember twice?
I don't want to say a wrong number under oath.
I'm not going to hold you to a number. Though I think the point that we're trying to make to the court is that it's been excessive. Now, I'm going to require you to explain to the court how many times.
Judge, I'm going to object. That's not relevant to this hearing, and the court can take judicial notice of the docket sheet. You're on mute, Judge.
Mr. Bancroft?
Your Honor, I do believe that it is relevant in that we're asking for a unification therapist, and it shows that the litigiousness of this case has been generated by Ms. Walpole. She suddenly can't remember how many times she's been to court, and she's admitted to at least 3 CPS complaints that are before the court. Asking the court to take judicial notice of the contents of its file is one matter. Having a witness answer the question at bar is a completely different matter, and I believe that on direct examination, it's a relevant and cogent request.
Okay. I don't know that there's a difference between 3 and 5. There's been multiple. That's clear. I'll sustain the objection.
Very well. Moving on. Ms. Walpole, would you agree that you have successfully destroyed the relationships with your other children and their fathers?
No, I didn't.
And if one of your children were to actually testify that you were very successful in that, would that be contradictory to your belief?
Objection calls for speculation.
If you know.
You have a question for me?
Yes, that's.
I'm sorry. Can you say that again, Anthony? I'm sorry.
If you know that your children harbor ill feelings about how you destroyed the relationships, would that affect your testimony today?
No.
Do you believe that it's important for Brooklyn to have a loving relationship with her father?
Yes, I do.
Do you believe that it's also important for her to have regular and consistent visits with her father?
Safe and consistent, yes.
Right. And at what danger would Sheldon pose to your daughter if reunification therapy were to say be once a week, a couple times a month, being supervised for an hour, hour and a half while in that therapy session with that therapist? Explain to the court what physical danger would be presented to the child.
She has PTSD. She's been diagnosed with PTSD.
Objection, non-responsive. I asked for a physical response, Your Honor, not an emotional or mental response.
Sustain the objection.
She would be triggered. It would trigger her PTSD.
And what if the allegation was due to suggestibility to the child? In other words, it's narrative that you've created to further push your agenda forward of no visitation for Sheldon.
I didn't do what he did to our daughter.
Okay.
He did that on his own.
Do you believe that Sheldon was sleeping and snoring when this allegation occurred?
Objection calls for speculation. She wasn't there. She has no personal knowledge.
Go ahead. Mr. Bancroft?
Your Honor, I believe that it's important that she brings the child to therapy based upon what she believes occurred. She wasn't personally there, but she had to present that child to the therapist and provide a narrative to the therapist. So I think it is relevant and she's capable of answering. Do you believe that Sheldon was snoring and sleeping is all I asked.
All right, I'll sustain the objection.
Very well. Ms. Walpole, do you know what the word incidental contact means?
No.
I'm sorry?
No.
If someone were to inadvertently back into you at the grocery store, say with a grocery cart, do you believe that that would be incidental contact or intentional contact?
Incidental.
Have you as an adult, have you heard or do you know as an adult, if someone accidentally brushed against you, shoulder, arm, back, hair, is that intentional or would it be incidental contact?
It's incidental.
Okay. If someone were sleeping or snoring, do you think that it's possible that incidental contact occurred?
I think putting your hands down someone's pants, especially your child, is wrong.
Objection, non-responsive. The question at bar, ma'am, was
I'll sustain the objection.
Answer the question at bar, not what you want to answer, Ms. Walpole.
Then can you repeat it, please?
Is it possible that it could be incidental contact if someone is sleeping and snoring and something like that occurred?
Yes.
No further questions, Judge. Thank you.
May I?
Yes, go ahead.
Laura, if someone hit you with a grocery cart accidentally and it broke your leg, would your leg be any less broken because it was incidental?
No, it'd still be broken.
Would it be any more broken if it was intentional?
No, it'd still be broken.
Would your broken leg still need treatment?
Yes.
What has Dr. Wei diagnosed your child with?
With PTSD.
What kind of therapy is she giving your child for PTSD?
She's undergoing an EMDR therapy.
Is Dr. Wei aware of today's hearing?
Yes.
Is she available to testify today?
Yes.
Does she oppose any reunification therapy at this time?
She doesn't think, not yet.
Not yet for
no reunification yet.
Okay. Now, CPS involvement with this case. Why was CPS involved?
Because of what Sheldon had done to our daughter.
And the previous 2 times?
Because he had been drinking and driving with our daughter.
Does Sheldon have a history of drinking and driving?
Yes.
Does he have a history of heavy drinking?
Yes.
Or would you like to see the results of the alcohol assessment that we agreed to back in November before we jump into anything else?
Yes.
You were asked questions about your other children. Your oldest is 27, is that correct?
Correct.
Did his dad live in Kansas?
Yes.
Did you live in Texas?
Yes.
Did his dad ever try to visit?
No.
Did you two ever go to court?
No.
Your second child is 22 years old. Is that correct?
Yes,
Has that husband, ex-husband, been in and out of prison?
yes,
For what?
for crack cocaine.
Does he have 50-50 possession per court orders?
Yes, he does.
Did he ever exercise it?
No,
And your 18-year-old child, has his father been in and out of prison?
yes, he has.
For what?
Methamphetamine.
And does your child talk to his dad?
He has started in the last couple of years, yes.
Have you two ever gone to court for custody?
Never.
So when Mr. Walpole says that you've tried to keep the other dads out of your children's life, is that a true statement to the court?
No.
Do you see the effects of the incident that happened in June in your child?
I do.
Do you think it's fair for your child to be forced to be in the same room with her abuser while she's not ready?
No, not at all.
Incidental or not, is your child traumatized?
Greatly, she is.
What are you asking the court to do today?
To give her the time she needs to get better.
Pass the witness.
Go ahead, sir.
Your Honor, nothing further for the witness. And the movement rests.
All right, Ms. Mazahari?
Judge, I just need a brief moment to call Dr. Way and see if she's somewhere where she can zoom in or call in.
Go ahead.
Thank you. Judge, I have called twice and both times it has gone straight to voicemail.
All right, do you have any other witnesses?
I do not, Your Honor.
Argument? Mr. Ryan?
Yes, Judge, I'm here. I was just trying to be quiet, so I didn't have to be feedback.
And that happened when you were muted, and I don't know what's going on. Go ahead, sir.
Your Honor, I didn't hear the question. I rested.
Argument?
Oh, yes, Judge. Your Honor, with respect to the motion to compel discovery, Your Honor, I think that it's the only way my client can exercise due diligence with respect to this case is to actually have the release of information. If everything matches up, then it matches up. But if it doesn't, as we suspect that it will, Your Honor, it's going to be a game changer in this case. And my client has the right to be able to defend himself against accusations. This is one of those most horrendous accusations that you are presumed guilty without innocence even being a question. It's not as if someone would say you drink too much or you smoke marijuana. That case is prove it. If someone says you did something like this, it's like, oh my God, I have to react on a basis of caution. Allowing my client to get this information to prove his case and potentially even prove his innocence is imperative to our justice system. So therefore, I would ask the court to order Ms. Walpole to sign the release of information so I can collect the text messages between mother and daughter for a very defined and precise time period, and between mother and Roy Good from a very defined and precise time. And there's no other solution to it, Judge. I cannot go based upon what the picture they want me to see. With respect to the reunification therapist, Judge, I think you heard it very closely, is that when she's ready. If there is an ounce of truth to my client's testimony that when he was married, he saw what was going on between the mother and the other children from other men. And based upon the extensive CPS investigations in this case, as well as her inability to suddenly not recall how many times she's been to court to modify his conservatorship, to take away possession and access, Your Honor, it's almost required that we got to force this into a situation. Spending an hour and a half to 2 hours with a reunification therapist who would clearly be in the best interest of the relationship with the father and working in conjunction with Dr. Way, I think is the right move. We would suggest a couple counselors up in San Antonio. The one that we know has immediate availability is Kelly Bernstein. She's a master's level and she is a forensic therapist. Dr. Diane, Ms. Mazahari can help me with Dr. Diane Trevino. She's exceptionally good. However, this is because she's so good, she's extremely busy. Getting into her office to visit with the father and child in this matter may take weeks. And it's already been 9 months. When is enough going to be enough? And then again, Your Honor, if there is something that's of a false narrative being presented to a therapist who's treating a child under a false therapist or a false narrative to support the mother's agenda is not appropriate. And I think having two people working together to help the father, child, and specifically the child is in the best interest of the child. Thank you.
Judge, to say that Dr. Way is operating under a false narrative means Laura Walpole has to have extraordinary skills to convince a 10, 11-year-old to fake all symptoms of PTSD for at least the last 9 months. That is absurd. It is absurd to say that a child can fake symptoms of PTSD. Her therapist is now doing treatment on her that is done on survivors of war, on military PTSD patients to help her through this. This child is suffering from the full range of PTSD, and no loving parent would suggest to throw her back into reunification therapy while he has sat for 9 months and is waiting for Dr. Tice to call him. That is absolutely absurd. On the phone records, our position is if the court is inclined to order us to sign a release so that they can compare the text we provided with whatever the phone company could have, I could see them asking for mother and daughter text, but mother and Roy Good does not make any sense. That just goes beyond what is at issue here, and we ask that should be denied. And we do agree to Kelly Bernstein or Dr. Dina Trevino if the court were inclined to order reunification therapy. However, we would like the court to make it clear in the order that the reunification therapist must communicate with Dr. Way and they must come to an agreement on therapy. Because otherwise, if a therapist sees an order that says start this, they're going to start it. They're going to want to follow an order, and this could be highly damaging and detrimental and set this child back in the progress that she has made. She has come a long way in therapy. Thank you, Judge.
And who is the other, Roy Good?
Yes, Your Honor. I was going to brief response.
Go ahead.
Your Honor, it's Mr. Sheldon Walpole's fiance is Christy Cover, formerly Christy Good, right? And without going too far into that, but that one is the epitome of litigious. We discovered that in early 2020, Laura Walpole and Roy Good met up at a church function and somehow became a unit of one. When this all came down, it just so happened that it was the weekend that both girls, Miss Cover's child and Mr. Walpole's child, were at the same residence. The background is that Miss Walpole, Laura Walpole, and Roy Good, the relationships with their exes is extremely acrimonious. And when the allegation occurred in June of 2020, they coincidentally managed to hire the exact same counsel, Miss Deborah Parker, God rest her soul. She's passed from us, Your Honor. And that was like, how did that happen? That they both hired the exact same counsel. And that's when I began to smell the skunk in the woodpile, which is why we have to exercise our due diligence. I want to see what Miss Walpole and Mr. Good were communicating about prior to, because as I mentioned, the relationship between their exes is so acrimonious that, I mean, in Bexar County, we've got 9 pages of litigation, 9, on Mr. Good and Miss Cover's relationship. And Mr. Walpole is approaching that in your county as well. And that's the relationship between them. I really think there's some collusion going on, and my client testified to that.
May I respond, Judge?
Yes, ma'am.
Roy Good and his ex-wife, Christy Cover, were recently involved in a modification. Mr. Bancroft represented Christy Cover. They just settled that case with mediation arbitration. Whatever Mr. Bancroft wanted from Roy Good should have been obtained in that case from Roy Good. I think that they were unable to get what they wanted, and now they're trying to take a second bite of the apple. He was a party. They had direct access to get anything they want from him. It is absolutely not relevant to this case.
In your honor, if I may, the mere fact that they're fighting so hard to prevent me from getting that information should be an indicator of what's there.
Okay. And what was it that Mr. Walpole was supposed to do beginning last fall?
In November, we agreed that both mom and dad would have an alcohol evaluation as well as psychological examination for Dr. Tice. Ms. Mazahari and I were working on precise language for Dr. Tice because he is a very precise man. If we don't give him enough information, he won't look in the directions that may potentially be there or that we want to. That's why that order was finally settled today. And that's what you have before you. That's the only reason Mr. Walpole did not proceed. And if Mrs. Walpole wanted to see that Mr. Walpole has an alcohol problem, she could have forced the issue as well, because that would be right in line with what she's been allegedly cleaning all these years.
And did Mrs. Walpole submit to any exams or tests?
No, Your Honor. Neither of them have, Your Honor. To be fair, neither of them have.
Judge, I need to make a clarification. I think Mr. Bancroft made a mistake. Only Mr. Walpole is having an alcohol assessment, not Laura Walpole. Laura is just having a psych eval, and neither one of them have done anything. But if Mr. Walpole's issue is, I want my daughter, you've had 9 months to get an order entered. That's a long time. If that's what was stopping him, he's the one who needs to be proactive.
And the contrapositive would be true, Your Honor. Mrs. Walpole's got everything she's wanted for all along. No relationship with the father.
Okay. Anything else from either side?
No, Your Honor. Thank you. Not close.
No, Judge.
Okay. On the text messages, I will order them produced in camera to a third party. The attorneys need to agree on. If you can't, I'll pick someone. I think it would be appropriate if it was a family law practitioner or something like that. And the order needs to say that the only thing that the person reviewing the texts would be looking at, and this can be the individual that gets the order to have them turned over, is there evidence of any sort of effort by Mrs. Walpole and this other individual to present false or manufactured testimony, or to have the children do that. So I don't care if they're talking bad about their exes, they're threatening to murder them. That's different. But
Right.
You don't get to see all the bad things your ex may have been saying about you. Where this is just about, is there anything that shows that this outcry was not an outcry, but that it was a manufactured, planned false allegation? And on the reunification, I think you're premature. We'll just wait and see what all these tests come back and say.
Yes, Your Honor. Is that a yes to the release of information being signed by Ms. Walpole?
That's a yes, but
Under those terms.
under those circumstances, and that'll be at Mr. Walpole's expense.
Yes, Judge.
And Judge, I think Mr. Bancroft and I can agree to someone.
Okay. All right, I will be on here for a while. I'm not sure how long. Do we need an entry date? Is that something you think you'll be able to work up?
Your Honor, I don't think that the order on the motion to compel is going to be very hard. It's very, very simple, very, very clear what you just ordered us to do. And then I'm sure that Ms. Mazahari has some sort of release of information that can be generated, and we can meet in the middle on this. We work well together and communicate.
All right, excellent.
And Judge, that's because Mr. Bancroft is nice. I take no credit for us working well together.
Okay, all right.
Good.
Is that all? So are y'all finished now?
Yes.
Yes, Your Honor.
All right, then you are excused. And on the criminal side, what do we have? We have a bond setting.
That's correct, Your Honor, and a bond reduction and a sentencing.
Okay, I need to make a phone call. I will be back in just a few minutes, I think, and then we'll start on those two things. So we've got probably another hour or something like that.
I would imagine so, Your Honor. I believe the sentencing, they said about 30 minutes. I don't think the bond hearing will take very long.
Okay, all right, I'll be back. All right, I'm going to go ahead and look over the pre-sentence investigation, and then we'll start on Spalding. Okay, are both sides ready?
State's ready, Judge.
Is it Mr. Keendaws?
It is, Your Honor.
Yes, Your Honor. I wasn't sure if it was Mr. Spaulding. Yes, I'm ready.
Okay. All right, calling CRW 2011-307, State versus Sean W. Spaulding. Both sides have announced ready. I've received a precedence investigation report from Ms. Davis. Had a chance to review it. Are there any, have the defense and the state both had a chance to look it over?
We have, Judge.
Yes, Your Honor.
All right, are there any objections or additions to it?
Not from state.
I'm not from the defense, Your Honor.
All right, go ahead, Mr. Keendaws.
Thank you. Mr. Spaulding?
Yes, sir.
Okay, there you are. All right. Your Honor, I'm just gonna, I guess I need to have him sworn in.
All right, Mr. Spaulding, do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, Mr. Keendaws.
Okay, thank you. Okay, Sean, are you working now?
Yes, sir.
And where are you working?
I'm working for Leveled Homes LLC.
Okay, and you do have a reference letter from them?
I do. I believe I sent one through you in a message, and then I have the physical one right here.
Good. Okay. And what is the name of your supervisor or employer? I'm sorry, your direct supervisor.
James Hendershot.
Okay. And what kind of company is it?
It's a mobile home leveling business. Well, we do pier and beam houses as well, but we re-level homes.
Okay. And how long have you worked with them?
Just going on, I just started this new job a week. Before that, I was working with Adam Ibarra at Adams Paint and More. He's a contractor.
Okay. And do you work with?
I got this job offered to make a considerable amount of more money, and with working with my buddy Adam, it was kind of here and there when he had work. With this job, it's 7 days a week, nonstop, every day. So, yes,
now,
go ahead.
Okay, I'm sorry. Okay, that led to my next question. So it is 40 hours a week?
Yes, sir. Plus.
Okay.
40
good.
plus.
Good. Now, how many children do you have?
I have 3 that live with me and 2 that live with my ex-wife that I get every other weekend.
Okay. So are you court ordered to pay any child support?
Yes, sir. I sure am.
Okay. And are you paying them now?
Yes, sir. I am paying. I get letters from them every month. I'm a little behind due to a period that I was without work, but I'm playing catch up right now.
Okay. And of course, now, can you give the ages of your children that you're paying child support on?
I have a 4, a 5, and my daughter will be 9 this week on the 6th.
Okay.
Or next week, sorry.
Mm-hmm. Now, do you have a partner?
Yes, sir.
Okay.
I do.
That you're in a relationship with?
Yes, sir.
Okay.
Going
Does she
on
help?
8 years.
Okay.
Yeah, yes, sir. Yes, sir. Well, it's a team effort, and teamwork makes the dream work. You know, I mean, I can't do it without her. She can't do it without me. We really rely on each other.
Okay. Do you have insurance for the kids?
Yes, sir.
Now, you've had probation in the past. Is that correct?
As a juvenile, I was on juvenile probation.
Okay. So, but okay. So since juvenile, when you've encountered charges in a criminal system, were you ever on probation? Do you remember?
Not since I was a juvenile, no, sir.
Okay. So let me ask you this. What assurances can you give the court? Well, actually, let me back up a second. Okay. What assurances can you give the court that you'll comply with the conditions of community supervision?
Well, sir, I spent a good part of my life being a screw up and making a mess of things. And I'm at a first time in my life where my life is going in a good direction. I'm not in debt. My bills are paid. My children are with me. I'm happy. I'm working every day. I feel good about myself. I've been clean and sober for almost 9 months. I feel the best I've felt in my life, and I don't want to live the rest of my life the way I have in the past. I want to move forward and provide a better life for my family and my children.
Now, if the judge does put you on community supervision, you're aware that there are several conditions, correct?
Yes, sir.
Okay. Among them, you're not supposed to drink, you're not supposed to do drugs or associate with people of disreputable character. Do you truly believe that that is something that you can do?
Yes, sir.
Okay. And, of course, you can't reoffend. Now, the particular circumstances of your case is you were caught with a weapon. So, I mean, would you be able to avoid any criminal liability, not just during the term of community supervision, but ever? Can you do that?
Yes, sir.
Now, I guess there's a 200-pound gorilla in the room. You have been, convicted of a felony before. Is that correct?
Yes, sir.
Okay. So what have you learned since then?
That every choice in your life has a consequence. And I don't want those bad consequences in my life anymore. I'm tired of being away from my family. They need me. And I don't have any interest in getting in trouble. I don't want to be in trouble. I don't want that life anymore. I've already taken steps myself I've alienated myself from everybody that I ever knew, and that's been the best thing for me. I've been able to come up financially, and start to build a life.
Now, and I'm going to ask this question because I know the state is going to ask this. At the time that you picked up these two new offenses, clearly you knew you were a felon, but what happened then? Was it a lapse of judgment? Please explain that to the court if you can.
Yes, sir. The friend of, well, I won't say a friend, a person I knew had the firearm. The firearm wasn't in working condition. I know of somebody who has a gunsmith license and was taking the firearm, just trading hands basically to have it fixed for an individual. It was a big lapse in judgment on my part. I don't deny that.
So do you take full responsibility?
Yes, sir. Absolutely.
Okay.
And
of course, there were two charges, so you take full responsibility. Is that what you're saying?
Yes, sir.
Okay. And I know I asked this before, but this is always very important when it comes to probation cases. Are you going to make an effort to just not reoffend?
Yes, sir. I'll toe any line placed before me. I'll do anything that's asked of me and then some. I don't have a desire to reoffend. The only desires I have in life is to create a better life for my family. And me continuing to get in trouble would diminish anything I've tried to achieve up to this point. And I'm not trying to let anybody else down, or myself for that matter.
and you understand if you reoffend, you could seriously be looking at prison time. You understand that?
Yes, sir. I do.
Right. Pass the witness.
Who's going to take this from the state?
I am, Judge.
Right, go ahead, sir.
Mr. Spalding, my name is Mark Lezay, and I represent the state of Texas. I'm going to ask you some questions. If you don't understand it, just please ask me to re-ask them. Is that fair enough?
Yes, sir.
Okay. You were born in 1982, correct?
Correct.
Okay. You were arrested June 2nd of 2001 for possession of marijuana. That would make you 19 years old, correct?
Yes, sir.
Okay. And you were on probation at that time, which was revoked because you didn't complete your probation, right?
Sorry about that.
Can I ask you a question, Mr. Lede?
I'm sorry, Judge.
I'm going to ask you to repeat the question.
Certainly. Mr. Spalding, you were arrested on June 2nd of 2001 for possession of marijuana. And you would have been 18, 19 years old at that point, correct?
Yes, sir.
And the court put you on deferred adjudication at the time. You failed to meet the requirements of it, and you were revoked and sent to county jail, right?
No, sir. I was sentenced to the zero tolerance boot camp. And upon my release day, I was picked up on a Bexar County warrant at the facility that got released after I had been placed into the boot camp.
On June 2nd,
and it was to my understanding that was taken care of, that I had completed it, because I went to boot camp, and then I went back to jail straight from boot camp and was re-released.
Okay. June 2nd, 2001, you were not a minor, correct? You were
No,
not
sir.
a juvenile.
No, sir.
Do you remember having a charge, cause number 787990 in Bexar County? You signed for 6 months deferred adjudication?
I don't remember signing for the probation. It's been a long time ago.
Okay.
Like I said, to my understanding, since I had gone to the boot camp and then I went back to jail and I was re-released, it was to my understanding that I was released from the probation.
Okay. If you don't remember, sir, fine, but you would agree with me that you obviously county jail term you served in 2001 when you were not a juvenile?
In 2001?
Correct. It was revoked October 31st, 2002, and you did 90 days county jail.
Yes, sir. You know, I do. I remember doing 90 days and getting time served on it, I think.
Okay. And so November 19th, 2002, you certainly weren't a juvenile then, right?
No, sir.
Okay. And I apologize. I'm talking about August 4th, 2003. You were arrested for evading arrest, detention, and DWI. And you got probation for both those charges, right?
No, sir. I did state jail time on those charges.
Okay. But again, I'm showing you cause number 030201 that you got 5 years probation, and October 12th, 2005, it was revoked, and then you did state jail because you didn't live up to your probation requirements.
Yes, sir. Yeah,
okay. So when you tell this court that you've never been put on probation except for when you were a juvenile, that's not true. We just talked about 2 incidences where you're on probation and you failed to complete probation. Correct?
Yes, that's what you're saying. To my understanding, I didn't think that that's how it played out as far as the probation being terminated. I was extremely young then and very naive, I guess, and I really wasn't paying attention whenever I was in court then.
Okay. You're 38 now, right?
Yes, sir.
Okay, and you're asking this court to put you on probation, correct?
Yes, sir.
And the 2 times you failed at probation, you still to this day don't even understand that you had obligations to complete or you were going to go to jail, and you failed both times. I mean,
Yes,
you
sir.
understand that now?
Yes, sir. I understand that now.
Okay. I mean, would you agree with me? You should understand that before you ask the court to yet again put you on probation for another felony?
Yes, sir. I didn't realize that that's how everything was documented, or everything that I guess I didn't understand the process, sir, is what I'm saying.
But you would agree with me, you should understand the process since
Yes,
you're
sir.
asking for the same thing?
Yes, sir. I do. I understand that.
Okay. And what you said earlier about you never being on probation as an adult is not true, correct?
Yes, sir. Yes, that would be a false statement. Yes, sir. I apologize.
Okay. Now, currently, you talked to Miss Davis, you and your partner and kids are living in a weekly hotel, is that right?
Yes, sir.
Okay. Y'all pay weekly to stay there?
Yes, sir.
And you use her mother's address so they can go to school?
Yes, sir. That's where she was residing before we moved into the she was staying with her mom and her mom's boyfriend who owns a house, and they have since split and threw them out. So she didn't want to just uproot the kids in the middle of the school year with all the corona and everything, and then being taken out and then put back in. And it was just, we're using her address just for the remainder of the year to keep them in school.
Okay. So if you were to go away, then they could go back and stay with her mom, correct?
No, sir. Her mom has been kicked out.
Isn't that what you told Miss Davis, that if you had to go away for some reason, whether treatment or whether it's prison?
Yes,
that
sir.
they
Within the last month and a half, her mom's boyfriend and him, they've been having problems, and he has asked her to leave the residence.
And in regard to what we're talking about, you were found with a stolen trailer, right?
Yes, sir.
Okay. And not only was it a stolen trailer, but it was a trailer that had another license plate put on it to hide the fact that it was a stolen trailer.
I'm guessing so. In that case, I have documents and proof that the trailer was not mine. I borrowed it from somebody just to move a washer and dryer for about 4.5 hours is all I had the trailer. I have text messages and documentation from him asking me for his trailer back.
Okay. So the stolen trailer is somebody else's fault. What about the glass pipe and baggie with meth residue found in the console?
No, sir, that was mine.
Not relevant. He wasn't charged with that.
I'll overrule the objection.
And I'm sorry, Mr. Spalding, what was your response to that?
Do I have to answer that? I mean, I will. It was mine. I'm not gonna lie. I'm a recovering addict. I've been clean and sober since August. When I got arrested, I've been out on bond for the last 5 months. I've maintained sobriety.
Well, no, that's not true, right? You tested positive for marijuana when you met with Miss Davis to talk about this pre-sentence investigation.
Yes, sir, I did.
Okay, so that's not true also. Right?
As a recovering meth addict, sir, I'm off meth.
Okay, so your claim is you're off one narcotic, but you're using another, correct?
No, sir, I'm not using narcotics anymore.
Okay, but you're using marijuana?
No, sir.
You tested positive for marijuana when you showed for the PSI, sir.
Yes, sir, I sure did. I'm no longer on. I'm not on
But
any
you-
narcotics. I can pass a UA.
Okay, but you claimed for 5 months that you were clean, right?
Yes, sir. I'm in off meth. I wasn't speaking in drugs in general. When I speak of my addiction, I had a meth addiction. I was addicted to meth since I was about 15 years old.
Okay, I understand that, but you certainly understand that marijuana is not a substitute.
Yes, sir.
Or
I understand.
heroin or anything else.
Yes, sir.
Okay.
I understand that.
I'll pass the witness, Judge.
Go ahead, sir.
Okay. Yes, thanks. Okay, Sean, if you were to send to prison, would your partner be able to support the children?
No, sir.
Okay. On her one income?
No, sir.
Is there anybody else that or could step up to the plate if something happened to you?
No, sir, we don't have anybody.
Okay. And of course, you don't deny that you've had infractions in the past. Is that correct?
Yes, sir, I don't deny that.
Okay. And of course, you stated that you do have a problem that you're dealing with, correct? The substance abuse problem?
Yes, sir.
Okay. But you understand that if you're placed on probation, you cannot use anymore. You understand that?
Yes, sir, I do.
Okay. But I guess the question the judge has, or any court would have in their mind, is, especially with marijuana, I mean, how can you convince this court that you're just not going to use weed anymore? I mean, how? I mean, because you tested positive. So what will motivate you to stay clean?
My freedom.
And what else?
It's what I need to do. I know it's against the law. I'm not trying to be that person anymore.
And also for your children?
Yes, sir. Mostly for my children. That's my whole purpose. I just want them to have a better life. I don't want them to have their dad around. I don't want them to have a drug addicted father as something to shadow their future. I want them to have a better future.
That's the witness.
No further questions, Judge.
All right, your next witness.
No further witnesses, Your Honor.
All right, Mr. Leday.
Judge, the state would call Gene Davis.
Davis, would you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth? So help you God.
I do, Your Honor.
Go ahead, sir.
Thank you, Judge. Ms. Davis, could you please state your occupation for the record?
I'm a community supervision officer for the 81st and the 218th Judicial District.
Okay. And how long have you been in capacity? How long have you been serving in that capacity?
6 years.
Okay. And in conjunction with your many other duties, do you also perform precedence investigations?
Yes, sir.
Okay. Were you asked to do one on Sean Spalding?
Yes, sir.
Okay. And what does that normally entail when you do a precedence investigation?
We ask we investigate their criminal history. We investigate their living circumstances. We investigate their drug usage. It entails an in-depth look at the person and their criminal background and how they are proceeding through their life right now and personally and with employment.
Okay. And when did you do this PSI on Mr. Spalding?
It was in February, so.
Okay. And during that time that he told you that he was living in a weekly hotel with his partner and kids?
Yes, sir.
Okay. And did you ask him about the fact that if he had to go away, whether for rehabilitation or for prison time, would those kids and partner be okay?
At that time, he did tell me yes, that they would could stay with her mother.
Okay. And in regards to this case, he has had 3 prior felonies, correct?
Yes, sir.
Okay. And this would be his 4th.
Yes, sir.
And every probation he has been on by an investigation, your investigation of his record, has he completed any of
No, he hasn't.
And in regards to his open plea, when he showed up for the precinct investigation, he tested positive again for drugs, correct?
Yes, sir, he did.
Okay, that was with the marijuana.
Yes, sir.
Given this regard, I mean, does the Wilson County Adult Probation often deal with people that go into rehabilitation?
Yes, we do.
And do y'all ever conduct any kind of analysis on their addictions or anything like that?
Yes, sir. We have a drug and alcohol evaluation that we do called a SASE.
Okay. Was the SASE evaluation, Mr. Spalding?
Yes.
Okay. And what does that entail? How do you do that?
It is a questionnaire that was developed by a university that talks about, that addresses questions of alcohol and drug abuse. And that questionnaire is then entered into a program. And that program, depending on their answers, that program determines what kind of addiction or non-addiction that they may have.
And how did Mr. Spalding?
I'm sorry?
How did Mr. Spalding do on the SASE?
It says that he has a high probability of a substance use disorder.
Okay. And so that's also reflected in not only his criminal history, but what we know about the meth being found at the truck, his arrest, and the marijuana positive test?
Yes, sir.
I'll pass the witness, Judge.
Go ahead, sir.
Okay, Ms. Davis, obviously, you don't know Mr. Spalding personally. Is that a fair statement?
No, I met him on the day of the PSI. I don't know him.
Okay, so, I mean, despite how he might have tested on the SASE questionnaire, you have no, I mean, you can't say for sure that, you know, he would test positive if he's placed on community supervision, correct?
No, sir, I can't determine. I mean, I can't answer that question because I don't know what tomorrow will bring.
Exactly. Okay, pass the witness, Your Honor.
Judge, no further questions.
Defense rose.
Okay,
Stay up.
let me ask. I think I asked this before, but what was the theft charge? Is that over the trailer? Is it over washer and dryer? What was the theft charge that is reflected on the papers in this case?
It was over the trailer.
That is correct.
And that was alleged to have been stolen from Bear County?
Yes, sir. Yes, sir.
Okay, Mr. Spalding, I'm going to ask you to hold on. I'm talking to the attorneys.
Yes, sir.
All right. So that was alleged to have been stolen from Bear County?
Yes, Judge.
Filed in Wilson County, just because it was in Wilson County when it was recovered?
Our only live charge, Judge, is the unlawful possession of a firearm by a felon.
Okay, but I mean, is that a Bear County charge? Is it a Wilson County charge, the misdemeanor?
Judge, I'm not sure if it's Bear or Wilson. I know it just didn't come within our jurisdiction, either by the amount or where it was officially charged.
Mr. Keendaws, what can you tell me about that?
Your Honor, I do know that, but I thought he might have had a misdemeanor in Atascosa, but I was not appointed to that, so I can't say for certain.
All right, because it has a cause number here.
That's what I thought, yes. For some reason, I was not appointed to that misdemeanor.
Your Honor, may I answer?
Yes, ma'am.
I called the county attorney's office on this charge, on the misdemeanor, and it is pending.
So they haven't filed it yet, is that what it is?
No, they haven't.
Oh, they.
Okay, I'm going to recess this. I want to know more about that because here's what I'm looking at. If whatever his record, if Mr. Spalding just had the bad luck to borrow a trailer with non-functioning lights from somebody who he thought owned it and who thought he had permission to use it, and he got caught with a felon in possession of a firearm, that's a bad case, but it's that. If Mr. Spalding is out supporting his drug habit by participating in or assisting in burglary rings where people are going around and stealing stuff from people's residences to support their drug habits, that's something very different. So I'm going to recess this. I want Mr. Keendaws, we'll set this for like a week down the road. And I want Mr. Keendaws to be able to get in touch with whoever the defense attorney is. And your client claims that he has all sorts of exculpatory evidence and see what's going on with that case.
Okay.
So let me ask Ms. Riley to give us we have a Wilson County date next week? That's mine.
It's, no, Judge, you don't. Let's see.
Does Lynn have a Wilson County date that I can just ask them to come over and see me for this one thing?
There's an April 5th date with Wilson County. That's with Judge Ellison's. Do you want that one?
Yes, just with a notation that it's going to be heard by me.
Okay.
It's
Unless you
April
want
5th.
unless you want like the 6th or the 7th, I could put it on, one of those dates where it's not like the criminal docket.
Well, let's do it on a date when the attorneys are going to be in Wilson County anyway.
Okay, April 5th then, Judge.
Thank you.
All right, if you'll post that, Mr. Keendaws and Mr. Spalding, you need to get in touch with Mr. Keendaws about whatever information you need to give him, and we'll see you back in court on, you need to be in probation on April the 8th, was it? No.
5th.
5th, okay. All right.
Yes, sir. Yes, sir.
All right. So is that all we have on the criminal cases?
I think Mr. Nitz wanted to be heard on Antonio Morales, Judge.
Yes,
All right.
Your Honor.
All right, give me just a moment to finish up what I'm looking at here, and then I'll get with Ms. Barrera so she can take off. Okay, it opened up this time on the Quadro.
Sorry, Judge, did you say you got it?
Yes.
Okay. And Judge, on the other matter, the Balmos child,
Yes.
we come to an agreement, and I put that in your chat also, but it's a Rule 11 agreement that I wanted to make the order of the court so that I could get an entry date.
Okay, yes, and I was going to say, I looked at that, and no, I agree that it's not self-executing. You're going to need to get a judge to sign something. So do you want to propose the date, or what do you want to do? Or do you want to just, is Ms. here? She was
having trouble with her Zoom audio, so I wasn't sure. I just called her on the phone. I see she's on there, but I don't know if her audio. Ms. Fox, is your audio working now? Can you unmute yourself?
Can you hear me?
Oh, yes, I can hear you. I looked at your calendar. You're going to be back in Wilson on April 19th. I can have the typed version to her before then.
Okay.
That date's actually full unless it's like a real short hearing.
Yeah, it's just for entry of the order.
Okay. Okay.
All right. Well, why don't you go ahead and prove it up so she doesn't have to be back, or?
Okay, I think my client might have gotten off, Your Honor, but I can ask her if she agrees to it.
All right, Ms. Fox, would you raise your right hand, please?
My right hand.
Do you solemnly swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And are you ready to proceed in the case involving your child?
Yes.
All right, go ahead, Ms. Barrera.
Ms. Fox, we worked all morning on trying to reach an agreement for final orders on Justin's modification action. You received a copy of that I have provided to the court. Do you think that those agreements are in the best interest of your child?
Right now I do.
And are you asking the court to approve those agreements regarding possession, access, child support, and conservatorship regarding the child?
Yes.
And you're okay, the judges, I'm gonna do a typed version of the agreement that you have in your possession already on your email. And I should get it to you before the April 19th doc date, but that April 19th is so that if there's anything that I send you, the typed version that's different from our agreement that you have currently, you can address that with the court. Do you understand that?
Okay. Yes.
And do you have any other questions regarding this or anything you want to raise to the judge at this time?
Not at this time.
And nothing further, Your Honor.
All right, and Ms. Fox, let me just restate what Ms. Barrera said a little differently. As you know, she's going to type this up and send it to you. If you believe that what she's typed up is your agreement, if you would just sign off saying that that's your agreement, you don't need to be back here on the 19th. If you believe that there's some way that what Ms. Barrera produces is not your agreement, or if there's something else that absolutely has to be subtle, that's not addressed in there, you need to raise that with her. And if y'all can come to an agreement, great, sign off on that. If if you just can't come to an agreement, then I'll see you on the 19th so that we can get that finalized.
Okay. Thank you, Your Honor.
All right. Well, wish you good luck. I'm glad y'all got this worked out.
Okay, thank you, Judge. Are you excused?
Yes.
Thank you, Judge.
Thank you.
All right. And all right, and this is Mr. Morales. All right, my computer's locked up. Is this Mr. Morales?
Yes.
Okay, Mr. Nitz?
Yes, Your Honor, this is a motion to reduce bond. Mr. Morales, you were supposed to be in court on February 24th, is that correct?
Yes, sir, I think so.
And you did not appear, is that correct?
Yes, I don't know if I was incarcerated or not, or if I was out. I'm not sure.
Well, if you were incarcerated, you would have appeared for the hearing. Can you tell me why you did not appear for the hearing?
Well, it's because I don't have a phone at the moment, and when I was in the free world, I don't have a phone, and I wasn't working at the time, so I wasn't being able to give me a telephone, you know, and I don't have much people to help me out and let me use a phone and stuff, so it was kind of hard for me to get a hold of the court.
If the judge allows you to get out one more time, how will you appear for hearings?
Because I have my girlfriend now, and she's willing to help me get my telephone when I get out. As soon as I get out, I'm going to get a telephone, and she's with me now and knows that she's going to help me keep track of my days and of being able to go to court. She's going to be my transportation. She's going to be my everything, you know, to help me get back and forth towards court. To if I need to come to Floresville or do what I got to do, she's going to be there to help me 100%, you know.
And you do realize that if the court does not, or if you don't have a phone and you can't appear by Zoom, that you're required to appear to probation. You understand that?
Yes, sir. But like that, she's gonna help me with the Zoom and all that. Cause like I'm not much of a phone person, but she's gonna help me with the Zoom, knowing so that when I need to get on phone, I need to be on the phone. She's gonna be the one to help me out, you know.
But you do realize that it is your responsibility.
Yes, sir, I do. But like I say,
And so if you break up with her,
no, I won't break up with her. We'll be, I mean, I'm saying, like I said, she's gonna show me how to use the Zoom, because I don't really know much about the Zoom, but she's gonna want to show me how to do it, you know?
and along with this case, you had a companion case out of the county court. Is that correct?
Excuse me? Well, the county court, well, they dismissed my charges. They threw my charges out, you know, so.
And those are charges related to the same.
They were the same charges that I got whenever I got discharged, you know, I mean, I didn't.
All right, and they were, those charges were dismissed for
They were
insufficient evidence?
dismissed. Yes, sir, they were dismissed. They were thrown out, so.
So you're currently unemployed, is that correct?
Well, I got a job now. I recently started working now, you know, so.
And
a job, because I'm locked up. I'm trying to get out. That's why I don't lose my job.
how much will you make an hour?
Well, I'm probably gonna be making between $19 to $20 an hour, maybe, you know, carpentry work. I mean, I'll frame out good houses. I'm a carpenter.
Okay, at the moment, do you know what your bond is, or your bail is?
20,000, I think, you know, which I probably won't.
Do you have the funds to afford?
I have no way.
pay
I have
that?
no way to get out. I have no one to get me out on that, you know. I won't. And
And
90-day PR, because they don't give it to you on a failure to appear. I'll be in jail for a long time. I mean, I'm have no way to get out, you know. I'm just.
all right, no further questions.
I'm trying to get out because I didn't do anything wrong, you know.
Right,
May
Ms.
I proceed, Your Honor?
Oh, Ms. Whitney, I'm sorry.
So, Mr. Morales, let's talk about this court case. You failed to appear in court on November 2nd of last year, correct?
Yes, ma'am, because I didn't know nothing about having to call for the court date. I didn't know nothing about it, you know. I mean,
You're telling this court you
I'm not a person on the internet. I don't get on the internet, so I really didn't know I was supposed to look it up, you know, so.
So you're telling this court you received no notice via mail that you court on November 2nd?
Mail-wise, no, I didn't. I didn't know I was
Okay.
supposed to look on the internet.
But you were arrested for that failure to appear, correct?
Yes,
And we came to court, correct?
today, yes.
And judge actually granted you a bond at that time, correct?
I'm sure, yes, she gave me a $20,000 bond.
A personal recognizance bond, correct? A PR bond?
I don't know if I got the PR bond. She said she just gave me I got a $20,000. The bond she gave me, the bond was a $20,000 bond, I think. I mean, I'm hoping.
But you were released. So if you didn't give the jail or a bondsman any money, then you were released on a PR bond, correct?
When is this? When are you talking about?
Well, in November, after you appeared in this court.
Well, November, yeah, it was $100 bond that I had got with the other case, you know. She offered me
And
$1,000.
on November 19th, you signed a waiver for the court case to make an appearance on February 24th, correct?
Yeah, and I did that over the Zoom. I did it over the Zoom on the other court date, on the other.
Okay. And you were given, so you were able to do that through Zoom at that time, correct?
Yes, and my girlfriend was the one that helped me through it, and we did it over the Zoom, so.
So the girlfriend that you're currently with?
Yes, ma'am. Yes, ma'am. She's the one.
Okay.
That case.
So you knew
the case got dismissed, you know, they dismissed the case, so.
Well, we haven't dismissed this case. You
No, the other case, I'm talking about the other case.
to appear in this courtroom on February 24th,
Mr. David.
correct?
Yes, ma'am.
Okay. And February 24th came about, and your reasoning to this court is that you didn't have a phone that you couldn't make a Zoom appearance, correct? That is.
Yes, ma'am. I didn't know I wasn't able to get a telephone. I wasn't able to get the telephone to be able to get on the Zoom.
You also understand that you could have appeared in the two courts.
Yeah, but I don't have I don't have no transportation.
So you don't have any transportation and you didn't have a computer, so you just decided you would blow off February 24th.
No, it's not that I decided to blow it off. I just had no way to get a hold of nobody, and I mean,
And you were picked up, you were arrested on this failure to appear warrant on March 23rd, correct?
Yes, ma'am.
Okay. And where were you picked up at?
At my place of residence there where I stay with my uncle.
So for a month, you've made no attempts to contact your attorney or the
It's not that I
missed
made
your
no
court date.
attempt, man. I mean, I had no way to be able to do it. I had a telephone, I had no way to get a hold of anybody, you know.
Okay. So for a month, you have
I
made
did-
no attempts
I
to
did
contact.
I contacted the booking to try to get a hold of Jason Nitz's phone number because I had lost his number too. I lost his business card and I couldn't get a hold of him either, so. I was trying to get a hold of him mainly. I mean, I tried to make effort to get a hold of him once, but I mean, I wasn't able to get a hold of nobody.
And now you're telling the court that because you have a girlfriend, that she will help you make appearances to court now, correct?
She's gonna help me make the court, whether transportation, whether telephone call, either way, whatever, however possible. She's the one that's gonna help me get through everything. You know, because I don't really know much of the internet. I don't get on the phone much, but she's gonna show me through all that and show me how to get a hold of everybody and how to do what I'm supposed to do.
And now, Mr. Morales, this is not your first run-in with the law, correct?
Well, no, ma'am, it's not, ma'am. But with towards this being on the internet kind of stuff, that it kind of is, yeah. But other than that, no, I've been convicted many times, you know.
And been to state jail, correct?
Well, yes, I've been to state jail before, ma'am.
So you note that if you miss a court date, you need to reach out to the court and some.
Yes, I mean, I've been trying to do that, you know, like I said, I've been trying to do that. But I mean, at the time when I got out of jail, I didn't have much. I didn't have a phone. I didn't have money. I didn't have nothing to actually be able to get to where I needed to be at the moment, you know, because I had nobody there to help me. So I was all alone, all on my own. So I tried. I mean, I did try. I did make an effort of somehow to try to get a job and try to get some money to be able to at least get a phone, to be able to talk to y'all in a way that I'm supposed to, you know.
Now, Mr. Morales, you said that I believe you told Mr. Nitz that you have a job available for you.
Well, I have a job, yes, it's framing houses, and I got a carpenter job with an old friend that I used to work with before. He's willing to offer to give me some work, you know, and stuff. And hopefully I still got it when I'm in jail now. I might lose the job from being in here, so.
Well, but you didn't have that job prior to you getting picked up on March 23rd?
Well, I had just got it, but I had already got the job. Had been working with him, you know. I got hired on really, you know. So
when did you get hired on?
Well, a couple of days ago, last month, when I went and asked him for the job, and he said, "Yeah, and I could use you. I could use you." So, but now I'm locked up, and I'm not gonna show up for the job. You know, I might not get it. You know, I don't know.
So you were able to get a job.
To get a job, yes. I told him, hey, and he told me, yeah, I could use you. I could use your help. So yes, I mean, he's willing to offer me to get a job, you know. So I'm trying to get out so I can keep the job, you know.
But you weren't able to reach out to the court.
But I mean, I didn't know that I was supposed to go to court. Like I said, I just did the Zoom with the misdemeanor court, and then after that was all done, I even asked my lawyer from that court, hey, do you know anything about my other court? Nobody never told me nothing. Nobody said anything about it. That's where I stayed at right there. I mean, that's where I stayed. Like, well, what do I do now? You know, I didn't know what I was supposed to do next. You know.
Your Honor, I have no further questions for this witness.
I don't know.
Mr. Nitz?
No further questions, Your Honor. As far as argument goes,
Mr. Morales, you said you were trying to reach out to the court. How?
Well, I tried to get a hold of Mr. Nitz, or trying to get his phone number to maybe call to find out what was I supposed to do, or when was I supposed to go to court, or what was the deal, because like one charge was district and one was misdemeanor. I didn't, and the other lawyer, she didn't acted like she didn't know nothing about this case. So I asked her too, Brandon, and she didn't know nothing about it. And like she's like, they dismissed this case. The other case, they dismissed it. They threw it out, and nobody never told me nothing about which case. What do I do now? And I did ask about it, but nobody never said nothing. You know, and this charge was given to me for I don't know what reason. I don't know what I did wrong. You know, I did not do nothing wrong. You know, I don't know how I got picked this charge up. You know, I don't know how this charge got pinned on me. That's what kind of got me lost here too. You know, I didn't do nothing wrong. They pinned these charges on me.
All right, sir. So I guess what I'm asking then is, they
got me for
reach out to the clerk's office or the court, or did you reach out to someone else?
Well, I called the booking and tried to ask for Jason Niss's phone number or whatever and stuff. And even when I was in jail, I had got his address, but they said there was no phone number. I mean, was gonna write him a letter, but I had wrote a letter when I was in jail too, and I never got no response back, you know, so, I mean, I don't know. That was the last time that when I got out of jail, I was like, I had all my paperwork at home. I still got everything in my folder that I got at home. I'm trying to figure out what's going on. What am I supposed to do next? You know, like, because I don't want to, I mean, I'm just not gonna let this go, let it go. You know, I know this is a big deal, you know, this is something I gotta tend to, you know. I mean, I'm trying to get out of this, you know. I didn't mean to miss my court date. I didn't mean to do all that, you know. Like I say, I mean, it was just kind of hard for me. I just
Right,
freshly.
sir, and what was the misdemeanor case that you picked up in connection with this case?
Well, I was breaking into a coin operating machine and criminal mischief were my charges that they gave me, saying that I broke into the laundromat and I broke a machine, but I never did nothing like that. It wasn't me that did it. I didn't do it, and I don't know how come. But this case is still pending. I don't know why. I don't know why they pinned this on me. You know, I mean, I picked these cases up for what reason? I really don't know. You know.
All right, any other?
I mean, this is just the other case got thrown out, and I'm just here stuck with this case, and I don't know what to do about it because I mean, I didn't do it to begin with. I mean, I don't know.
Okay, Mr. Morales, I'm going to ask you, direct you to stop point on. Any other questions for this witness?
Nothing further from the state, Your Honor.
I have one more question. You had the misdemeanor case. Did you appear for those hearings?
Well, I did it over the Zoom.
Over the Zoom.
Over the
At
Zoom.
that time, you had a phone.
Well, I did it over my girlfriend's phone. I used her phone.
And when those cases were dismissed, did you think you were done?
Well, that's what I asked because I asked my other lawyer. I asked Brandon. I asked him, hey, can I get a hold of Jason Nitz? What do I do about the other charge? What do I do about the other case? She just said, I don't know. I mean, you have to get a hold of them because it's something else. Nobody never told me nothing. And that's where I stayed at right there. Like, I mean, what do I do now? I mean, that's whenever I told my girlfriend, I said, well, all I can do is call booking and try to get a hold of his number. I don't have his number anymore. All I got is his address. All I got is your address, Jason Nitz's address. That's all I got. She told me, well, write him a letter. I said, yeah, well, I've already done that before too. I mean, and that's where I stayed at right there. I mean, nothing else. I had nobody else to get a hold of, nobody to talk to.
Okay, thank you.
So all I try to do is get a job.
No further questions.
And where do you live, sir?
I live in Stockdale, Texas, sir. I live with a handicapped uncle. I mean, he's pretty much the only person that gave me a place to stay when I got out of jail. So, I mean, I'm there kind of helping him out.
All right. Go ahead, counsel.
Your Honor, obviously, it's important that he show up to the court date. Obviously, and it's clear there's some confusion based on the fact the other case was dismissed. And the fact that the other case was dismissed for insufficient evidence, and I can send the dismissal if the court requires. Indicates that there's a strong possibility that he's not actually guilty of this case or could be found not guilty. We don't want to keep an innocent man in prison for any longer than he needs to be. And it's clear that he didn't try to flee. He didn't leave the county. I asked that he be released on a personal recognizance bond. If not, significantly reduce the bond amount.
Okay.
So,
but let me just ask before we go any further. Was Mr. Morales in court the day his county court case was not dismissed? I read the record as saying until the 4th of this month, which was what, 6 days, 8 days after he was supposed to have been in court.
210100011 CVS.
So was he in court, in county court on the 4th of March?
I apologize, Your Honor. I'm in another hearing that just went off. The question is, was he there on the 4th, March 4th, when it was dismissed?
Yes.
I was in court. I was there. It was Mr. Dickie Jackson was the judge, and I was in the Zoom. The court was probably over about an hour's time, hour and a half's time. When I was on the phone, the Zoom, and finally my name came up, and they said, "We're going to dismiss the case. Mr. Morales, you're dismissed. You're free to go." That's what they told me, And then that's when I got off of the Zoom, and then I was done with that. And when I called the booking to try to get a hold of Mr. Nitt's phone number, but they said they had a record of it. So then I went from there. That's where I stayed at from there. And I just didn't know what else to do, until now I got arrested for failing to appear. And that's why I'm here now.
But you understand, Mr. Morales, that you already failed to appear at that point by over a week. Ms. Whitney?
Your Honor, we would ask, his bond is set at $20,000. I believe that, Your Honor, that is an appropriate bond. Mr. Morales has failed to appear in this court twice. It has taken him being arrested twice for him to appear in this court, or he still would not have appeared, Your Honor. The fact is whatever happened in the misdemeanor case happened. This is a completely different case. It is not a misdemeanor case and has, it may have arisen out of the same episode, but that doesn't mean we cannot proceed with our case. I believe Mr. Morales just told the court that he was able to Zoom multiple times for his misdemeanor cases, yet he seems to not be able to Zoom for his felony cases. And with that, Your Honor, we would ask that the bond be kept at the $20,000.
All right, Mr. Nitz.
I just reiterate, he's not a flight risk in the sense that he never attempted to flee. He didn't attempt to evade the arrest. Obviously, he's had issues getting here. I asked that the court show mercy, give one more chance, because again, though it's a different case, in each case, it relies on a identification. The county court, the county prosecutor decided that there's not enough evidence to go forward even, and we think there's a strong possibility that he will be found not guilty. And so we're asking that he be given one more chance to get out, and if not, at least reduce the bond enough so that he has a chance.
Listen to the evidence. Mr. Morales, I will reluctantly restore whatever your previous bond was. But I'll tell you, sir, that without prejudging anything that comes in front of me in the future, you need to go through life looking for a way to make things good happen and to keep bad things from happening, and not looking for reasons and excuses to say, well, it's nothing to do with me. As Ms. Whitney pointed out, you managed to show up for court in county court, but you couldn't manage to show up for court here. So I will agree with Mr. Nitz that shows just that you were not paying attention or not motivated sufficiently to do what you needed to do to get in touch with the court. You, as Ms. Whitney said, you've been in touch with in the system before. I think that you could have found somebody's phone there in Stockdale to call the district clerk's office here in Floresville. So I will, if somebody will get me an order that says that, I will restore his previous bond. We need to get a court date. I want to know on the record here so that Mr. Morales has no excuse that he didn't know what his next court date is. So Mr. Nitz, what court date are you selecting?
4/21 is the next pretrial. So 4/21.
All right, please post that. Mr. Morales, you need to either be at the probation office or appear on Zoom. And then after, we're hoping right now, the 1st of May, court is going to go back to in-person court, at least for most things. And you need to be in court in person at that time.
And just to be clear, Your Honor, when you say you're going to restore the previous bond, you mean the previous PR bond?
Whatever it was. I'll sign an order setting aside the NISI and restoring the previous bond.
Okay, thank you.
Where do we stand on Dennis Lee Smith?
I show that was reset, Your Honor, to 419 for MTR.
That is what I have as well, Cindy.
We have dates on everybody now, I think. Sean Spalding. No, actually, what date did I give? Was it 4/5?
Yes, sir.
Okay. And what is next Thursday? Next Thursday is the 8th. Okay. All right, Ms. Riley. I show I have.
Yes, Judge.
Buckets next Thursday. Does that look right? Frio County and the like?
I'm sorry, what was your question?
I have the civil dockets next Thursday, Frio County and the like.
I show you have the criminal dockets next
Okay.
Thursday, next week, actually.
All right, whatever I have next Thursday, please look and see. It needs to be not terribly long. I mean, I'll do what I can, but they're decided to give the life skills class 2 days of at-home instruction next week, and we just found that out this morning.
Okay.
And my wife is going to take one. I'm going to take one. And I guess what I'm saying is I'll be home with Rusty, but I can operate from the bathroom and get along there. But I'm not going to be able to have he and the dog entertain each other for all day long. So
Okay.
I certainly at half a day at most is what I can do. They may not have that much.
I'm not sure how many cases are set right now. I can run it real quick if you want me to, but I can let Jennifer know not to set anything else.
Yeah, please. And again, half a day, but not more than that because
Yes, sir.
he's going to be going wacky at that time. All right. Anything else we need to do?
I don't believe so, Your Honor.
All right. And you're going to get that order to me, Mr. Nitz?
Do you want him to submit to you, or do you want him to drop it into e-file and me forward it to the coordinator? How do you want this to work?
That's fine if he's not going to get it right now. I'm going to shut this down and the Acrobat down and hope that I will be able to go into my.
Okay, and I'm going to kind of grab the PSI I brought to you earlier so I can return that to probation on Mr. Spalding. Or do you need to?
No, that's great. No, actually, yeah, just leave it in the, let's just leave it in the file for the time being. And
okay.
Where do we stand on Balmus? I'm sorry, what date did they get? 4/17, 4/21?
On who?
The first child case.
It was April 19th, Judge.
4/19.
Is that correct? Yes. Yes.
4/19 entry. Okay, I'll put 4/19 entry. And reset on request on the Walpole child. They're supposed to submit an order.
No, we're trying to, I'm doing things different from him and I'm the one that's making the mess and I realize that, but I don't apologize for it.
All right, I think that's everything. So.
Civil is done. Yes, Judge.
All right. Oh, and on Richter, final judgment, just it was a sign, but they can close it out. Okay. All right. Anything else?
Sorry, Judge, I noticed that you unmuted me. Did you want to address me? I jumped over to Atascosa Court briefly. Did you need me to address something?
Yes, if you'll just, whatever order you come up with, let the state have a chance to look at it and then please e-file it and I'll get it signed.
I will do that.
All right.
By the end of the day.
Okay. All right. Y'all are excused. Have a good day.
Thank you.